Honorable members, good morning.
Good morning, Chairperson. We can hear you loud and clear.
There's
Morning,
something
Chair.
not happening with my...
Morning.
Oh, yes, I can hear. Thank you for helping me also with that sound check. Good morning, honorable members, and good morning to our colleagues from Parliament, from PMG. I saw colleagues from PMG here, and any other people that I may have forgotten to greet. So today we're going to continue considering the Road Accident Fund report, which is, I have to confess, is is a lot harder to write in a manner that passes the quality control standards required. So we're doing it in sections, and today we are going to try and tackle two sections. So my suggestion is that we do the first one, take a break, and then do the second one, and then wrap up. And then I think our next session should be our last. As you would have seen, the documents are quite long that have been sent so far, and we still have quite a few sections outstanding, although I believe they will be a bit shorter than what we've got at this point. I just want to make sure that Miss Ibrahim is on. Isn't the
Yes,
meeting?
Chair, I am here.
Okay. May I please burden you? We are going to do the direct claims first, and then we will take a break and then do the cancellation of the panel of attorneys next. So can I burden you with projecting that on the screen, or even if it's one of our colleagues? But I think if you are driving, it should be easier.
Yes, Chair, no problem.
What I'll do is I'll preface in the meantime while you are putting it up, to say that one of the challenges, of course, is working out what best to extract out of the hearings themselves, where there has been extensive witness testimony, because people spend entire days with us, sometimes into the evening on some occasions. So there is a lot that was said, but the important thing is to pick out the details that matter, and make sure that they're corroborated by other evidence, including minutes of meetings and other submissions that we received. This therefore means that we've got to draw the line somewhere. We can't have a very long report, because we're effectively repeating what was put on. So we're going to start with the matters relating to claims, and I'll hand over to you, Ms. Ibrahim. This section is 14 pages long. I think the next one about 20 pages or thereabouts. So may I please hand over to you?
Thank you, Chairperson. Chair members will be happy to know we're not being paid per page, so we are making an effort to try to keep it as short as possible, but there is quite a bit of information to get through. So, Chair, this section on direct claims will fit into Part B of the report. As we indicated in our last meeting, Part B of the report is where we deal with all of these substantive issues. And the next part of the report is where we will do the recommendations. So this part would have the overview, the summary of evidence in relation to a particular matter, as well as the committee's observations and findings, but it does not contain recommendations, which we'll deal with separately. So to start off with, Chair, in terms of the overview of the issue of claims processing and the related expenses, members will be aware that the number of claims that the RAF receives is obviously directly linked to the number of road accidents. So because we have a very high rate of road accidents in the country, it obviously then impacts on the number of claims that the RAF will receive. So the RAF did explain at some length to us that it's difficult then for them to plan adequately, because one doesn't know in advance what the number of road accidents would be. So the RAF then evaluates each of these claims individually, including a claim that may be made by a dependent. And of course, the claim has to be based on the negligence driving of another person. So each passenger, pedestrian, injured driver, or dependent submits their own separate claim in accordance with the prescribed RAF1 form and with their own evidence. So the fund operates under a fault-based insurance model as per the Act, where for a claimant to succeed with a claim against the RAF, it must establish that the damage or loss suffered did not result from that claimant's own negligence or other wrongful act or omission. And this is really what then creates a difference of opinion, because there isn't a set amount that would be paid to people for specific injuries or for specific things. The first thing that needs to be ascertained is whether there is any fault and how that liability will be calculated. Section 17 to 21 of the Act, which we read together with the regulations there to provide more information on that liability. And it explains that a claim is instituted by submitting the prescribed RAF1 form. Section 23 of the Act then provides for prescription of claims, and this was quite an important matter that we dealt with right at the onset to try and understand where attorneys come in to the picture. So in terms of the Act, there's a 3-year time limit for claimants to lodge their claim. And that time limit would only apply in the case where there's an identified driver or owner of the vehicle. So you know who the vehicle belongs to, or you know who drove the vehicle. Then you've got 3 years in which to then submit that claim. Where there's an unidentified driver, so that would be cases of usually of a hit and run, that period is then reduced to 2 years. So that's your original prescription period. So in other words, if you don't do anything within those periods, your claim prescribes. And if you were to attempt to then submit a claim after those periods, the RAF would have no legal obligation to consider them. There are some exceptions to these rules. So for example, in respect of minors, patients detained in terms of mental health legislation, or persons under curatorship, but those are exceptions to the norm. Once that claim is then put into the system, so once it's been validly lodged, the claim can still prescribe, because it must still then be settled within 5 years from the date on which the cause of action arose. So if the cause of action is the accident and you've submitted then on the anniversary of the 3-year period, you would then only have an additional 2 years by which the matter then must be concluded. If the matter is not included, in other words, there isn't a suitable offer that's been made that a claimant accepts, then the only way to interrupt that period is via summons. And that is where attorneys come in. So up until this point of having to issue the summons, it is in fact not necessary to have an attorney. But to get to the stage where one may want to interrupt summons for whatever reason, where there's dissatisfaction in the way in which the claim has been handled or the offer that's been made, one would need to then resort to the services of an attorney. And members would have heard that there are attorneys that really specialize in these RAF matters. In terms of Section 24 of the Act, the claims process is set out. To lodge a claim, unfortunately, the way in which the Act is drafted, a person must send that claim by registered mail, or they must hand it in person. So unfortunately, the Act has not kept up with the way in which the world has changed. There's no way in which to submit claims other than via these two methods. And that is why we see the large volumes of physical files that members would have seen during our oversight visit and the previous oversight visit in the last Parliament. There's then a need for a medical report, and that would be filled in by the relevant doctor that would have treated that person. And obviously, where a person's killed, you wouldn't have that medical report, but a claimant, which would then maybe perhaps be the beneficiary, would have to submit documentary proof, such as an inquest record, or a copy of the relevant charge sheet where somebody else has caused that accident. Claims can be processed directly, as I've indicated, or through a legal representative. So at the get-go, a person, an ordinary individual, would have the choice of whether to go via an attorney or to try to tackle the process themselves. As I've indicated, there are attorneys that specialize in these processes and that would hold the hand of a claimant from the very beginning and lodge the claim on their behalf. The fund is then given 60 days to verify and validate that claim. And claim objections must be made by the RAF within 60 days from the date of lodging a claim, failing which the claim will be deemed valid. So if the RAF doesn't have its house in order and doesn't look at that claim once it's arrived within the first 60 days, the way it would work is that that claim is then deemed valid. So your prescription periods and so on would then be kicking in because that claim is now in the system. So a claim that is successfully registered will be issued a unique link number, and in terms of that number, the claim is then processed. So this all happens in a fairly litigious and dispute-ridden environment, and these cases we've seen take years to be finalized, and there is this massive backlog that the RAF has always struggled with over the years. The claim expenditure, therefore, is the largest expense item in the books of the RAF. There would obviously be other expenses in terms of labor and so on, and the administrative costs, but really it's claims expenditure that is the largest cost. And that claims expenditure would also include legal costs. So in 2013-14, the total claims expenditure amounted to 22.2 billion. And 4.6 billion of this, or 21% of that total expenditure, went to legal fees, of which 1.7 billion was spent on the RAF's own legal costs and 2.9 billion on claimants' legal costs. Because, of course, what happens is when these matters go to court, the court then may award costs in favor of the claimant. And the RAF, of course, would have had to pay its own panel of attorneys to defend these matters in court. So that is where those legal costs are arising from. 86%, as of 31 March 2025, the claim expenditure amounted to 42.6 billion. So we can see there's been quite a jump there. And 86% of that expenditure was compensation towards the claimant, with a balance of 11.4%. Accounting for the processing costs. The committee then considered whether there was in fact a decision to discourage direct claims, and if so, what would have been the costs related to that. There were quite a number of public submissions that alleged that there was a decision to halt the direct claim strategy. So not to halt direct claims have always been allowed, but rather the strategy which would have been to encourage direct claims, was stopped. And the key witness on this section of the inquiry was Ms. Christina Mtetwa. She's the former RAF manager for origination. And she took the committee through historically what happened. And she explained that in 2014, the RAF had developed this direct claim strategy as a collective intervention for the highly litigious operating model. So the RAF was fully aware at this point that there was what I would term an over-reliance on lawyers, and they were trying to then change that. So the strategy was reduced to adopt that over-reliance on external attorneys and then improve direct access for the public to RAF services. And the whole purpose is then to shift the focus away from lawyers and litigation back to the intended beneficiaries. By doing so, you obviously then end up with more funds in which you can then honor these settlement costs, because the moment you have attorneys involved in the process, that's going to impact the bottom line, as it were. So in implementing the strategy, the fund then introduces dedicated structural pillars and various outreach measures, and these are captured quite succinctly in Ms. Mtetwa's affidavit. They included dedicated departments, being the information department that she headed, as well as a direct claims department. And there were then special staff that were trained to then work in these departments. And they included direct claim officers, origination consultants, and case managers. There was also the establishment of customer service centers, and there were 5 such service centers that were established in the regional offices, and they were strategically located to reach claimants in areas that previously had no RAF service points. As I indicated in the beginning, a person would have to physically lodge their claim or send it via registered post. Since you couldn't use email or any other method of delivery, these service centers then provide an extra way in which an ordinary member of the public can then access RAF services. And importantly, they then have the assistance of in-person help without necessarily then having legal representation. So one can go in and speak to a warm body. There was also then stakeholder collaboration and outreach pursuits that were undertaken, and this included having mobile officers. So these assessors would then go out. There was collaboration with the South African Police Services that would let the RAF know when an accident had occurred, for example, and assist the RAF in getting necessary documentation. There were partnerships with state and private hospitals. There were hospital service consultants at major hospitals and an expanded direct claims department. So the committee would have heard a little bit about Sunshine Hospital in this context, where there were these dedicated consultants that were based in the Sunshine Hospital. In addition, there were then physical offices that were also established within certain hospitals. And there were, by 2014, the RAF had a physical presence inside approximately 95 public hospitals. And these were staffed by at least one dedicated RAF consultant. And what this meant is that a person who then has been in an accident and is admitted in hospital is able to lodge that claim while still there, making it much easier for the victim of that accident, rather than having to leave the hospital and then figure out how this claim needs to be lodged and what documents would be required. So that consultant would then have access to the doctors to get the medical reports and so on, and they would assist claimants really at that point of entry. These hospital case managers also provided other medical and rehabilitation services. So there was that ongoing element of support. This enables claimants then, in short, to lodge claims directly with the RAF and eliminates the need then to go through attorneys. So it makes the RAF more accessible, efficient, and victim-focused. There were initiatives like RAF on the Road. There were attempts to improve the call center responsiveness, and all of this is then done with a view to reducing the amount of litigation that had, as I've indicated, been consuming a large proportion of the RAF's resources. It also then becomes a way in which claimants are protected from unscrupulous attorneys if that was a challenge that they may have been facing. So in the years following the implementation of this strategy, the originations increased sharply. So in 2015-16, there were only 22,524 direct claims, and that almost doubles to 40,986 in the 2018-19 financial year. And those figures come directly from the RAF annual reports. And the RAF then also reports that with the origination of claims, they then also save on legal costs. In terms of evidence, the committee received various submissions alleging that the RAF at some point issues a directive to discourage these direct claims, leading to the collapse of claimant support services. So you'll recall that Ms. Tetwa had indicated that the assistance that these units provided wasn't just at the point of the registration or lodging of the claim, but they would hold the hands of victims throughout by assisting with rehabilitation and other costs that may have cropped up as the years progressed. That would have included payments to caregivers and so on. And all of this then is suspended. In addition to this, there's some labor-related consequences. So we found that many of the people that wrote to the committee as part of the public participation process complained about this, the fact that their services were terminated or they were subjected to disciplinary proceedings, which in their view was directly linked to the RAF now wanting to discourage direct claims. So in other words, their roles or their jobs were no longer needed, and therefore they suffer some sort of occupational detriment as a result. So the committee aimed firstly to ascertain from witnesses whether there was indeed such a directive. Is there something in writing that specifically provided that the strategy was going to change and we were now going to discourage direct claims? And if so, what would the rationale for such a decision have been, and what the extent of the impact that decision would have had on both claimants and the financial affairs of the RAF? So in week one, that was when we had our orientation hearings. The RAF officials who appeared before the committee at that point noted that they didn't recall any such specific directive, whether verbal or otherwise, but they did concede that the number of road shows had reduced, but they couldn't explain to the committee what the reasons were for saying. We then heard from Mr. Macintosh Palela, the head of communications. Members will remember him well. He was the one that constantly addressed members as my lord. And when he was asked about direct claims, he shared that only about 3% of claimants claimed directly, and 97% claimed via lawyers. And he indicated that when he started at the RAF and he presented his communication strategy, and that would have been in or around October 2023, he was told by the then acting Chief Corporate Support Officer, Mr. Ian Burrell, who the committee also heard from, that the RAF does not promote direct claims. So in his words, that was made abundantly clear to him, and he therefore had to remove this from the strategy and not promote it. He did emphasize, however, that the RAF, whilst not actively promoting these direct claims, didn't stop them either. Interestingly, though, Mr. Palela made a comment that such claims are not permitted by law. And he said, ever since I came, it was made abundantly clear to me that legislation does not, as we sit here and now, allow that. As I understand, it was a pilot. Chairperson, that is not our reading or understanding of the Act. Whilst we appreciate that attorneys come in at the point where a summons needs to be lodged, certainly there is nothing in the Act as it stands that would prevent a direct claimant from lodging a claim themselves. And if that claim can be seen through till the end without the need for summons, then certainly there would be no need for lawyers in that process. During that same hearing with Mr. Palela, we also heard from Ms. Shlami Mache, who was the suspended senior marketing manager of the RAF, and she testified that when Mr. Letswala was appointed as the new acting CEO in September 2019, he had indicated that anything pertaining to the promotion of direct claims must be withdrawn in line with this new transformative strategy of the RAF. And her unit, the marketing unit, was then instructed to no longer promote direct claims. And she testified that prior to this, the focus had been the opposite. There was a focus on the RAF to drive direct claims. And so in terms of their communication and marketing strategies, they were focusing on RAF on the road, and everything that they did was to try and promote ease of access. And members would have also heard that Mr. Palela then explained at this point that the marketing strategy had changed, in that there was then also a focus on road safety as opposed to the direct claim strategy that was there prior. So there were different efforts made by the marketing department then to try to reduce road deaths through advertising, and they had certain events and so on that he had taken the committee through. Notwithstanding that obviously would not have fallen within the competence or the responsibilities of the RAF. That's not their job to do that. So Ms. Mtia elaborated that in January 2020, and this would have been prior to COVID, her team had to pull all the advertising that was already on the logs in all media, a decision which, according to her, would have cost the RAF millions of rands. because what would have happened is you would have booked these media slots, and now because you're taking a decision not to use those slots, those would have been slots where you would have advertised the process for lodging dialect claims. Notwithstanding that you're not using those slots, you would still have to pay for it because you've now cancelled. We were not able to put a figure on that amount, but that is her testimony. She also indicated that a lot of the branded marketing material had to be put into storage or otherwise destroyed because it was no longer needed. So she said that we had a lot of branded marketing collateral in terms of gazebos and marketing materials that had to be brought back into our storerooms. Ms. Christina Mtetwa told the committee that the dialect claims and associated case management structures were dismantled in late 2019 and early 2020. And she detailed that in January 2020, during a Microsoft Teams meeting, the regional manager, Mr. Bede, gave an instruction to cease all direct claim services and remove the branding. So that accords with what we've heard from the marketing section. She also shared that 2 senior managers were with her in that meeting. But again, she stresses that there was nothing in writing. There was no formal written directive or circular to management on this change in strategy. So the committee then heard that what followed is that in February 2020, the hospital-based staff are recalled from their stations, and the customer service centres and hospital-based offices that had been established were then scaled back. So by mid-2020, the effect is that they were reduced to handling historical inquiries or old direct claims. So they're not facilitating any new claims. They were not allowed to originate new direct claims, but only assist walk-in clients. She was probed extensively on who gave the instruction for direct claims then to be under promoted, and what she was able to provide the committee was an internal email from the then Chief Operating Officer, Ms. Jabavu, in 2020, which read, "We can assist with walk-ins, but we should not go out and aggressively look for direct claims. We should also explain to claimants that they have a right to claim directly or via an attorney." So she shares that essentially in the 2020-2021 financial year, the RAF had entirely halted its campaigns and projects to encourage or facilitate direct claims amongst the public, and their marketing and communication budget for public outreach was cut. And she referred the committee to the RAF's 2020-21 annual report, which attributed this to the reality of the COVID-19 pandemic. But of course, what we've seen from the dates is that much of this happens prior to that first lockdown, which I think would have been in March of that year. So media payments then fall to zero, and that's depicted in this table that we have below, and that covers print, television, radio, out of home, and other value-added media services. The committee also hears from Ms. Mtetwa that all systems and databases used to manage these direct claims were deleted or dismantled. So members may recall she said that suddenly the entire SharePoint system was removed, and so was all the policies, standard operating procedures and guidelines that they would have had access to on their internal system. So when they tried to access these documents and records, they simply no longer existed. And this was something that concerned her because there was an investment in infrastructure, and there's obviously all of this institutional knowledge then that is seemingly destroyed. The committee then also heard, as I indicated, from Mr. Ian Burrell, the former acting Chief Corporate Support Officer, and he shared with the committee that he was not aware of any specific instruction to halt the strategy. This notwithstanding that we had heard that when Ms. McIntosh Palela had presented his strategy, he was then told, according to him by Mr. Burrell, that he would have to remove the reference to direct claims. He did, however, confirm that there was no appetite, in his words, for direct claims, as they did not form part of the new strategy. And his understanding of this was that most direct claims were lodged without sufficient documentation for successful processing, and therefore there's a limited appetite to promote them. According to him, there was a view that direct claims, in my understanding of the RAF Form 1, that most of these claims were registered and did not have the documentation it was supposed to have for a successful lodgement of the particular claim. So there really was no appetite for direct claims in the new dispensation. I can confirm that. So you sit with a situation where the complaint appears to be that at the point of lodgement, people or claimants don't have the necessary information, and therefore we don't want to deal with it, as opposed to having a strategy that says, well, how can we assist our ordinary claimants to put in fit for purpose claims that our office is then able to actually take through the process. Instead, the view seems to be, well, we simply won't encourage this because it creates more problems. He was probed on what he meant by lack of appetite, and he explained that before the new strategy and before Mr. Litswalo, there was a direct effort to go into communities to register the claims, but after Mr. Litswalo had joined, the initiative was stopped. And he confirmed that that would have included the project for that on the road. His evidence is supported by the testimony of Ms. Mutya in response to a question as to why she would not advocate for someone to come to that as a direct claimant. Members will recall that she made a statement saying that notwithstanding that she herself is a holder of an MBA degree, that she's not able to fill in the RAF 1 form. So she herself would speak about this with team members, and their view was that they would never personally, as RAF employees, attempt to lodge a claim directly. And she, of course, said, well, if a person of her educational background is not able to do this, how would one expect an ordinary citizen who isn't educated to be able to do that? The committee then further traversed the issue with the RAF executive management. The first person being Ms. Manyashi, who was the suspended head in the office of the CEO. And she explained that it was stopped following a discussion between executive management and the board, who were of the view that the RAF cannot go out and tell people to bring direct claims when the RAF itself was not able to deal with those claims. And she listed some of the challenges with the direct claims. She noted there was difficulty in finding claimants, something that we hadn't heard before. Claims prescribing because summons are not issued, and the fact that the RAF cannot issue summons against itself. So members will recall that I had mentioned earlier that where a claim is lodged, there's still that 5-year period from the date on which the cause of action arose in which the matter must be finalized. If it's not finalized in that time, you would then need to issue a summons so that prescription can start running, so that you can halt, so that prescription doesn't run, in other words, so that you can halt the prescription. And it seemed to be that there was this concern that if you had a direct claimant, so a claimant that isn't being assisted by an attorney, and the claim then is not dealt with by the RAF timeously, so even if it was simply sitting on somebody's desk and hadn't received the necessary attention, that claim then would prescribe at the hands of the RAF. So even though there may not be any fault on the claimant, so not necessarily a situation where a claimant was made an offer but is unhappy with the offer and has refused to accept the offer. But even in a case where the RAF hasn't attended to that file at all, that matter could then still prescribe, notwithstanding that the fault then in that scenario would completely be on the hands of the RAF. And the only way then to disrupt that process would have been to issue a summons. And the question then that she raises is that the RAF was concerned that they couldn't issue summons against themselves, and that they would then have to be suing themselves to interrupt that prescription period. So she indicated that on 18 December 2020, the EXCO had indicated that direct claims will stop, and she said it was in their minutes. And following that, then days later, it's when Project Shaniela started. And that project was a project to wind down direct claims and finalize them. And that was now simply just dealing with the backlog. And you may recall that Ms. Christina Mtetwa said that some of the staff were then allocated to serve on that project of winding up. When the inquiry resumed, we also then met with former RAF board members and again traversed this question with them. And Ms. Msibi, the former chairperson, corroborated what the committee had heard from Ms. Kamalo. And she shared that there was a discussion during the board strategy session around the promotion of direct claims. And she again also echoed the sentiment that there was this legal concern that the RAF could not issue the summons against itself, as I explained. And that is why the decision was then made that the RAF itself does not have the power and should not go out to seek claimants for direct claims. So it seems to be a little bit of strange legal reasoning in this regard, that because you have a situation where a claim may prescribe and that prescription can only be interrupted via summons, that the effect of that would be that you can't have direct claims. But as I've indicated, of course, the Act doesn't say that. And nothing would have prevented a direct claimant from utilizing the services of an attorney from a later point in the process and not from the outset. So in other words, only when an attorney was in fact actually needed. So the former board shared that while it agreed that the RAF should stop soliciting direct claims for legal reasons, it was management's decision that resulted in the physical closure of the access points at the hospital, effectively then making it harder for legitimate claimants to get help. And this, of course, becomes a barrier of entry for victims who might find it difficult to go to the regional offices. So it seems that the board takes cognizance of the strategy and agrees with the strategy that these direct claims are not going to be encouraged, but at the same time don't get involved at all in the operational decisions that follow that. We then move on to observations and findings, and the first one is that the implication of the decision to halt the promotion of direct claims is that the strategy then was effectively abandoned. Marketing and advertising linked was withdrawn, roadshows were discontinued, and all this leaves claimants with no reasonable alternative but to seek assistance from lawyers. This, of course, would have disadvantaged claimants, particularly in rural and outlying areas, because these claim originations were moved to customer service centers in bigger towns and metros. And we see that direct claim settlements flattened due to this change in strategic direction, as we depict in the graph below, which comes out from the 2020-21 annual report. So the number of claims that the RAF processes each year subsequently declined significantly. And the committee did request the RAF to provide statistical data on the successful claims submitted directly by claimants vis-a-vis the claims submitted by lawyers on behalf of claimants. And the RAF shared the table which we've pasted below, depicting the total number of successful personal claim lodgements and registrations for the period 1 April 2018 to 31 March 2025. And they've separated by direct personal and represented personal claim registrations by financial year. And so the impact, as you can see from that, of the decision to halt the promotion of direct claims, you see that there's a sharp decline from 33,000 direct personal claims registered in 2019-2020 to only 4,620 direct personal claims being registered in 2020-2021. Represented claims also decreased marginally, but as a proportion of all claims registered, direct claims are negligible compared to claims then that would have been registered by lawyers. Obviously, during this period, you would have had COVID, which would have obviously caused a reduction in the number of road accidents because of the various lockdowns. But of course, that doesn't change the fact that in terms of those accidents that did occur, it's clear that very few are then lodged via the direct claims method. So the committee finds that there was indeed a shift in strategy to dissuade the lodging of direct claims from 29 onwards, notwithstanding that the RAF at this stage had put into place various costly mechanisms and structures to facilitate and encourage the lodgement of direct claims. So it really is a 360-degree turn in terms of strategy, notwithstanding that quite a bit of resources had been ploughed into the strategy prior to this point. It appears to the committee that the decision was partially due to the fact that direct claims, as I indicated, were lapsing in the hands of the RAF, and this would have been to the detriment of direct claimants. And whilst the RAF Act does not require a claimant to lodge a claim via an attorney, it does provide that a claim which is lodged but not settled before the 5-year period prescribes. And I won't take the committee through what I've already explained about that prescription period and the interruption via summoning. Safe to say that you then have a situation where direct claims were prescribing really because those claimants don't have the benefit of attorneys to interrupt the prescription. In some cases, these claimants may not have even known or been aware of the fact that their claims were about to prescribe, especially when you're dealing with people that don't have the requisite legal knowledge or the ability to understand the Act. There appears, however, to have been no regard for dealing with the root cause of the prescription. So it doesn't seem that this question was asked. Why are these claims not being finalized timelessly? So we know claims are prescribing. The solution surely can't be to say, well, we're simply not going to encourage direct claims. We rather leave this to lawyers so that they can issue these summons when need be. Instead of asking the very hard question of what is causing these claims to lapse in the hands of the RAF? So what is the root cause of this? Is it because we don't have enough warm bodies dealing with these claims? Do we not have the necessary systems? Where are things going wrong? So the RAF doesn't turn its focus on the reasons for the delay, and they make no attempt then to put into place systems to facilitate the conclusion of the claims process, and rather they simply pull the plug. This obviously would have had an adverse impact on claimants, especially the most vulnerable in society who do not have access to legal services or who lack the ability to ensure that their legal practitioners act in their best interest. And the committee has heard quite a bit about the role of attorneys and the fact that attorneys don't always act in the best interests of their client. In addition, it would have resulted in financial losses, including the losses associated with the destruction and non-use of marketing material, the shutting down of all of these structures, the cost of media products purchased and not utilized, the costs associated with having to pull the people that were based in these offices, to close these offices, and so on. We were not able to put figures on these, but there is no dispute in regards to the fact that obviously there would have had to have been an associated loss suffered with the decision. A further cause for dissuading the lodgement of direct claims appears to be linked to this introduction of the new RAF 1 form. So the committee's already established that the form places onerous requirements on claimants at the point of submission, and this translates into a situation where direct claimants are unlikely to comply because it's so difficult. Instead of ensuring that these claimants are then assisted in lodging their claims were rather than simply not encouraged. And this position of the link with the RAF 1 form is supported by Mr. Burrell and Ms. Mathieu, as outlined in the earlier part of the report. So the committee cannot find any practical or feasible benefit in halting the marketing and promotion of direct claim, as long as claimants are aware of the choice that they have to consult an attorney at any point during the process. So on the contrary, the use of attorneys in the face of RAF already struggling to process claims timelessly only led down the line to an increase in default judgments and adverse cost implications for the RAF. So this really is the irony, because on the one hand, you have the RAF saying we sit with a legal issue where claims are lapsing in our hands. We don't want to sue ourselves, or we cannot sue ourselves. So let our claimants use attorneys. This is going to save us money. But of course, what happens is that similarly, even where attorneys are being used, claims are still not being dealt with timelessly. And you then have attorneys now issuing summons, and the issuing of summons obviously attracts other legal costs. So the entire process then becomes more costly. And when you have attorneys then going to court and there's default judgments and so on, you have a situation, and we'll deal with it in the next part of the report, where the RAF isn't even able to defend these matters. So claims are possibly inflated, and the RAF is then having to pay more than what it would have paid had it simply dealt with the matter the way it should have at the point that the matter is then lodged. So in other words, there's no evidence that the use of attorneys vis-a-vis direct claims facilitated the speedy conclusion of claims. And interestingly, the committee notes that Mr. Letswala has publicly complained about corruption in the legal fraternity at the cost of claimants, yet claimants appear to have now been deliberately left with no viable alternative in the wake of the dismantling of the direct claims strategy and the introduction of the new RAF1 form, but to seek assistance via these very same lawyers. It's either a case of you throw your hands up and make a decision not to lodge your claim because it's too difficult, or you now go to an attorney asking for assistance via those means. The committee, as I've indicated, was not able to quantify the loss suffered by the RAF in respect of the dismantling of the strategy. The committee, however, notes that these costs would have included wasted costs in respect of the training of staff. Ms. Mtetwa said to us that staff were especially trained and placed into these positions, the destruction or the non-use of marketing materials and advertising contracts, the closure of the hospital-based offices, including the wasted costs of improvements, renovations, and the purchasing of equipment. You may recall that Ms. Mtetwa said to us that these offices were improved within hospitals to allow their staff then to have a suitable office to work from, and that obviously would have come at a cost. And then there, of course, are the labour-related costs in relation to either finding alternate posts for those staff that get pulled, as well as the cost of personnel actions against key staff associated with the direct claims function. And we will deal later on in the report with the cost of labour-related matters. The committee further notes that the manner in which the decision to halt the marketing and promotion of direct claims and the later implementation of that decision appears to be informal in nature. There's no clear rationale, no clear instructions, guidelines, and consequence management steps being put into place, which is why we found that staff was struggling to indicate whether there was in fact something on writing, notwithstanding that this is a huge decision with practical consequences. This is similar to the decision in respect of the change in accounting policy, where you don't see anything clearly in writing and no clear direction and background work being done when a decision is made. So similarly here, there doesn't seem to have been any attempt to seek legal advice on the change in strategy. We weren't provided with any legal opinions on the issue of prescription. And this is particularly concerning given that Mr. Palela testified that he was expressly informed that there was no legal basis for direct claims. So you sit in a position where you have an extremely senior person saying that legally we can't allow direct claims, but yet we don't have this in writing. None of the witnesses could recall any specific directives. And then you also have a situation where staff on the ground are not provided with clear steps to follow, and there's a lack of planning then to deal with the inevitable gaps that were created. And Ms. Mtetwa's evidence that institutional knowledge was then destroyed was not contradicted. So even if there is a decision that the strategy for direct claims must be discouraged, there's nothing in writing in terms of a plan to indicate, well, what do we do with everything that we've established thus far? What do we do with the paperwork, with the policies, with all of this institutional knowledge? Do we put it on hold? How do we preserve these things so that they can be used at a later stage when the RAF is able to figure out how best to deal with the matter? So we've described it as a decision that's then being implemented in a covert and haphazard manner, because it really seems that no one had any clear indication of the change. It seems to have been small little instructions here and there. Pull people from these offices. Don't use your marketing material anymore. I think Ms. Ntetwa had said to us that they were told, when there are these multi-victim accidents, not to go out to the accident scene, whereas before they would have made sure that they were on scene to help people from that very point onwards. But there's nothing clear now in writing as to how we're going to move with this going forward, and it appears to be haphazard. The committee further notes that the halting of the strategy contravenes several of the basic values and principles that bind public administration as per Section 195 of the Constitution, and the RAF as an organ of state would be bound by Section 195. And the first of those principles is the efficient, economic, and effective use of resources must be promoted. Here we have a case where key resources, including physical resources, as well as your institutional knowledge, are destroyed with adverse financial implications. The next principle is that public administration must be development orientated. So services should be provided in a manner that's efficient and effective, and which ultimately then contributes to the well-being of the people. This is why we have a RAF in the first place. And what the halting of the strategy does is it has the opposite effect in as far as it limits accessibility of RAF services. And that then has the effect of preventing the RAF from fulfilling its very core mandate, which is to provide support to victims of road accidents. The next principle in Section 195 is that services must be provided impartially, fairly, equitably, and without bias. But the halting of the strategy meant that the most vulnerable in society, your illiterate, your economically disadvantaged persons, are prevented from accessing the services of the RAF, notwithstanding that these most vulnerable members of society are equally entitled to the services of the RAF, no more than you or I. And it shouldn't be that the only difference between a person like myself that's educated and that is fortunate to be gainfully employed is that I can afford or have access to an attorney, and that I'm able to hold my attorney accountable, as opposed to somebody that has equally suffered in an accident, but unfortunately doesn't have the means either to access that legal support. And if they do have the means to access an attorney, they don't necessarily have the means to hold that attorney accountable. So notwithstanding that their claim then does go through the system, there's actually no real tangible benefit for that claimant. The next principle is that people's needs must be responded to, and the public must be encouraged to participate in policy making. And the strategy fails to take into account the needs of the majority of that claimants. So there's no evidence that any step were taken to assess the impact of the decision on claimants. The committee therefore finds that the RAF management, supported by the board, took a decision to halt the strategy without the benefit of any claimant impact assessment report or cost-benefit analysis or the benefit of any legal opinion. The halting of the strategy, together with the introduction of the RAF1 form, was a means of reducing claims and in turn the liability of the RAF, notwithstanding that the RAF is legally bound to satisfy valid claims. And this is in violation of those principles that I've taken the committee through in Section 195 of the Constitution. The decision then also has adverse financial consequences that would have resulted in fruitless and wasteful expenditure, because this is expenditure, these are funds that you've now used to set up all of these various structures, contracts that you've entered into that you're simply now pulling away from at a cost of taxpayers' money. Also, the decision is not taken in a direct, open, and transparent manner, and there's no proper direction provided by management or the board to staff on how the decision was to be implemented and gaps were to be managed. And this really is a reflection then of poor governance, because one would have expected that a change in strategy which had this many implications and really speaks to the heart of the work that the RAF does would have been recorded in some detail, and there would have been quite a bit of planning that would have surrounded this. But similar to the issue that we saw with the change in accounting policy, it's simply void of all of this background work that one would have reasonably expected there to have been before the change in strategy is decided on and implemented. Thank you, Chair. That brings me to the end of the section, Chair.
Thank you very much, Ms. Ibrahim, for presenting this part to us. I'm going to give the members an opportunity to comment, ask questions, and so on, while you catch your breath and drink some water. So I'll say two hands for now. So I will take Honorable Atkinson first, and then Honorable Beasley next, and then we'll kind of respond or note what has been said, and then we'll go on to the next round. So Honorable Mende will then be the first on the next round. Honorable Atkinson, please go ahead.
Thank you very much, Chair, and also thank you to those who wrote this report. I think it's a very, very comprehensive capturing of everything that took place as far as the issue of direct claims is concerned, and it shows correctly the process whereby when we started out, we were led to believe that RAF was still doing direct claims, but as time wore on, when we got to speak to Mrs. Tweta and to McIntosh Pelela, we realized that the situation was something quite different. The point I want to make here is that what comes out very clearly in this presentation is the fact that direct claims are being basically pushed aside, almost based on the failure of RAF to be able to process claims timeously. So in essence, we basically accounting for internal failure, which seems to be a very bad situation to be in. And I know if this, as is recommended in the report, if the direct claims issue is ever to work properly, it would need some fairly major changes in the internal processing system at RAF itself. So I know we've spoken before about this issue of settlement hubs, whereby the RAF would need to employ sufficient actuaries and lawyers and various other people into settlement hub to result in quick resolutions of claims where offers can be made based on a predetermined list of compensation paid for certain injuries and that sort of thing. And I would think that a settlement hub would work very well in the case of direct claims. It would alleviate the problem of prescription, because I do see the whole concern around direct claims is the fact that RAF's not able to process claims fast enough. And then what happens in the issue of prescription, where RAF actually can't basically summons itself. So that for me is kind of the core problem here. And I see that the report does obviously recommend that the issue of direct claims is further looked into and made more available to members of the public. But in that regard, they would have to have some sort of settlement hub as well, or some means of being able to speed up the processing at the heart of RAF. But I just wanted to make that point, because I think that's kind of the fundamental point of what's actually in this report. And it will require, obviously, internal change at RAF itself. So thank you.
Thank you very much, Honorable Atkinson, for that. We've noted that what you've just shared just now. Thank you very much, Honorable Beasley.
Thank you, Chair. So just to confirm what Honorable Atkinson said, just hats off to the drafters. I think it's exceptional. Just a couple of points from our side. Clause 27. I think we need to refer to it's a new RAF form that couldn't be filled out, and we don't highlight that. I think that there was difficulties with, you needed an MBA to fill out the new RAF form, and I think 27 doesn't highlight that particular point. It's mute on that, because I think the filling of I can't fill the new RAF 1 form. It was talking to the new RAF form, not the old one. And then in paragraph 36, we talk about direct claims settlements flattened. I think flattened is too generous of a word. I think this direct claims decreased significantly or sharply, but I think flattened says it was a gentle flattening, but certainly wasn't. They fell off the cliff. So I think flattened is probably the wrong word there. And I think for me, the key thing here that stands out, Chair, and I'm glad that the drafters raised this, is the fact that we can talk what we like, but the impact of the direct claims has impacted the most vulnerable in our society. And I think for all of us as members in Parliament, I think we need to sit back and just take note of that the most vulnerable in society has been impacted by this and by the failure to do direct claims. So I think that's very good, because it's not just about money, it's about the impact on people. And then 48.4, the final thing, this is a reflection of poor governance. I think poor is possibly too gentle a word to, I don't know, maybe a stronger word, but a lack of governance or complete lack of governance. But I think poor is just too general, but that's just my personal thinking. Thank you, Chair.
Sorry, thank you very much, Honorable Peasley. You've kind of helped me recall also that I think I had said last time that we would start with finalize the previous section. So what we've realized is that the sections are interlinked, and we're going to have to, once we've done all the sections, do the entire thing together, because there are also sections that deal more substantively with the issues that are dealt with sort of, I would say, in passing or just in context. The rough one form is a topic on its own that is going to be dealt with, because it's extensive. It involved litigation, and it was a major change that led to a lot of impact also on claimants, financial impact on claimants, and also in terms of what then became expenditure on litigation. But thank you very much for those comments. Let's take Honorable Mende and Honorable Skosana. Honorable Mende first.
Thank you, Chair. Good morning to the colleagues. Similar to what Honorable Beasley was raising, on 12.4, where we are mentioning the collapse, or rather the removal of the satellites in hospitals and other satellites that were there for ease of access of claimants to RAF. We don't have a clear substance or additional information to that, which then is coupled with the resolve, like it is the case on all the other paragraphs on the bottom. Want to check do we have then a separate topic for that, or we then need to have a paragraph that speaks to the satellites, then are also lack of access now, how it has impacted the people on that particular one. Then a resolution on the communications component versus that's in paragraph. No, it's not paragraph 41, but the paragraph that speaks to how we have heard from Polela that and others that there must be a halt of direct claim marketing related work, and that's then led to the expenditure, which was fruitless and wasteful, in a sense that we mentioned that the gazebos and other material had to be destroyed. We firstly need there to put the figure in a monetary value so that it makes more sense as to how much are we talking about here when we discouraged the marketing related work on the direct claims. And then number two, we need to also explain as to that particular marketing was then diverted or rather changed into a promotion of something else, like your drive safe kind of related messages, which was not supposed to be a case, because a core mandate is for claimants to have access, is for claimants to know where they get RAF, is for claimants to know the information which could help them to claim successfully with all the completed documents, or rather all the documents required in order for their claim to be a conclusive claim and a claim that makes sense to the RAF officers. I feel like we did not then have information that speaks to that, because if we do not highlight the existence of the communications component, which is mainly there to speak to our people and take the message to our people, we are now changing RAF to events. They're merely running events. They're printing T-shirts for golf events, for parties, for all those things, which was a core message that RAF was supposed to be driving. But I also remember in the committee, we dealt a lot with Paulela as to what purpose does the current communications mandate drive in RAF. And he could not give us a clear answer as to this current mandate, who is it servicing? Because it made no sense. It doesn't speak to the mandate that there must be access. It doesn't speak to the people. It does not serve the entire purpose of the existence of communications at RAF. So I'm explaining this, trying to make it easy for the drafters where to go and what to do. Then there is evidence that I feel we need to include here. I'm just not sure, Chair, which document was provided to us with this evidence. The evidence that had a graph which was depicting a slow pace on the offers, the quantum, as well as the release of payments, which also is a contributing factor into the slow pace of paying out until the 5-year term has ended for many, and then their claims are prescribing. There's someone who gave us a draft and with their evidence is showing us that there's a system at RAF where from quantum to offer to the payment, it takes forever. And they put all the claims in 1 year, but as you proceed to the next year, there's very few claims that are dealt with, that are taken to quantum, and then there's very few claims that are paid out. And he gave us a term on what that system was that slows the quantum, the offer, and the claim. I feel like we need to add that information also, because it became a contributing factor in this 5-year that becomes a prescription for many of the claimants. And in a long run, then it discourages many people from going into RAF without lawyers so that they can have summons and all of that. Thank you, Chair.
Honorable Mende, in fact, I'll come to you, Honorable Skosana, just now, just quickly. The stronger paragraph about the satellite offices. Certainly that should be put in here, because I think that discussion is important. I also remember, so I'm accepting your other comments. So I'm just commenting on the ones that need an answer. The graph you are referring to, I recall it. I think it was bar graphs that tell you which claims are at which stage, and it gives you an indications of how many have not yet been processed. You can see them piling up, and then you can also see how many have been concluded. So it's onboarding, and then it's registrations, it's those that are outstanding, and then it's those that are finalized. I remember it. So we will look for it. I think particularly the last two annual reports have those graphs that you talked about. So I think it will be important to find. I agree with you. It's important that we find those. I'm also accepting the other points that you made, so I will not repeat them. Honorable Skosana. Oh, Honorable Skosana had his hand up. Honorable D. Skosana, no, he doesn't anymore. Okay, honorable members, are there any further comments? Because if not, we will take a short break, because we virtual. I think we can take a 10-minute break. There's
I'm
no.
here, Chair.
Oh,
you hear me?
sorry, I didn't see your hand anymore. So yeah, I was giving you a chance to speak.
Yes, thank you, Chair, and good morning to my colleagues as well. You know, I'm going to be very short, Chair. Simply for me, if those forms for those who wants to claim directly are simplify, you know, the report, as I'm saying, the emphasis, I don't see the emphasizing that. I'm saying, let's not complicate issues. You know, we just have to put systems to make sure that there's not fraudulent claims, you know, by whoever, lawyers, doctors, and the people, you know, our people as well, those who are finding themselves needing to get paid by road accident fund. Simplify the form. We've debated this matter many times. And I'm saying, you know, in the high side that the issue of well, which I don't see on the report, maybe I've missed something. The issue of foreigners, you know, being, I think it's a matter of, I don't think it's a matter of debate as well. I think we agreed that, you know, it is really not fair for our people. I mean, when we go to other countries, you know, we know exactly what happened, what is happening to you when you are outside this country, you know, and let's emphasize on those issues. Those are bread and butter issues, and not make it academic. You know, let's just be clear about that. Thank you, Chair.
Thank you very much, Honorable Skosana. No, those sections are still coming. Members will recall that the Road Accident Fund also furnished us with a table that said how many non-South Africans claim from the fund and how much that is, and so on. So that information has been provided by the Road Accident Fund. Honorable Mende.
No, apologies, Chair. I just forgot one point. We need to elaborate on the law, because many of the witnesses, especially key witnesses around this particular area, were mentioning that no, there are no provisions in the law for direct claims. The law says it must be lawyers. Can we get an elaboration, a paragraph that
Yes,
gives, that clearly defines what are the provisions in the law and what does the law demand?
Yeah, no, absolutely. In fact, the fact that they continue to process those claims even now shows that there's no problem. Otherwise, they would shut them down completely. They can't have it both ways, where it's not lawful, but then they report on 2,500 claimants, which seemingly can go through okay. So I agree with you, Honorable Member. We'll do that. Honorable Nilmay.
Thank you. Good morning, Chairperson. Good morning, my colleagues present here. And thank you very much for the report. It was very concise. It was very readable. And I think the comments that were given by my colleagues before are very relevant. I think one of the things that when it came to the claim form, we wanted to put our feet in the claimant's, put our shoes on in the claimant's foot to actually see how simple can it be, how easy will it be for our claimants to claim. And I think one of the areas that when we go forward with our recommendations, and I know it says there that we won't be making that type of recommendation, but we can maybe bring it to the attention that as my previous colleagues have mentioned, the form needs to be simplified so that people can actually claim. And I think the report is very factual and much appreciated. Thank you, Chair.
Thank you very much, Honorable May. Honorable Atkinson.
Chair, I might be jumping the gun a little bit here, because I do see that there's going to be a report on Sunshine Hospital, but obviously Sunshine Hospital came up in this sort of quite obliquely. There does appear to be quite a bit of movement in the sense that there does appear to have been quite significant payments made by RAF now to the Sunshine Hospital liquidators. And I'm just wondering if maybe we should send a letter to RAF and actually ask for an update on the situation, because I do think if we do provide a report on the Sunshine Hospital as we're intending to do, that the world might have moved on quite significantly on what information we have in there. So I think it might be quite good to try and capture the updated situation of exactly what's going on there. It's just a thought that's relating to claims. Thanks.
No, thanks very much, Honorable Atkinson. Just a quick answer. There's the Sunshine section is undergoing quality control, and that part, basically the drafting, it goes up to the court cases that were decided recently. I think as recently as a week ago. So
Okay.
I've seen that section, but it's undergoing quality control at the moment.
All right. Thank you.
Thank you very much. Honorable Madlala.
Thank you, Chair. Thank you, Chair, and greetings to the colleagues. I think to echo the sentiments of my colleagues in terms of welcoming the report, and you'd forgive me if this was ventilated in relation to this claims process. We definitely agree with promoting direct claims, and I think one, we also agree that it's important to simplify the form so that there is no need, because I think the structure of the system was such that, I don't know, deliberately or not, the complication was made so that there's an intervention of the lawyers, which is what we do not think is progressive. But also there is despite the simplification of a form, there is a role that was played by, I think it's the claims officers, where there was where we saw a mass dismissal, and there seemed to be a clear instruction that of downsizing, of cutting off that very important front line, which should be tasked with the responsibility of assisting claimants that are finding it difficult to complete the form. So I'm saying in the immediate, that should form part of our reflections and possible recommendations to reinstate that, because it's a critical aspect of ensuring that there's a facilitated direct claims process. Thank you.
Thank you very much. Yes, that's actually very important. I don't want to speak out of turn. I do think that it exists in one of the coming sections, but I will check because it is important. But it's also worth mentioning here because they also gave us numbers in terms of how many people were then lost in the claims handling area and so on. What you will see in the section on the RAF 1 form is that what made it complicated were the document requirements. Those specialist reports that you needed to get. And also in terms of the cross-referencing to others, you will also see that what is said in this section about needing those medical legal reports then is compounded by the fact that someone may be in a rural area. So you have a complicated form because of the medical legal reports, but then someone is far from major centers and they've got nobody to help them. And therefore, it has that impact. So, but thank you very much for those. We'll just the team will look at this section with the benefit of your comments and also make sure that there's consistency across the different sections. Thanks very much, honorable members. Can we resume at 11 o'clock for the next section? Thank you very much. Welcome back, honorable members. Can I just do a sound? I'm sure you can hear me. Ms. Ibrahim, are you back on? Okay, not yet on.
Yeah, Chair. Apologies,
Oh,
I didn't realize I'm muted.
No worries. Shall we project the next section and go through that one?
Thank you, Chair. Denzel will be projecting. Chair, this next session, we're now dealing with the cancellation of the panel of attorneys. And I just want to point out at the outset that when we speak of the cancellation of the panel of attorneys, again, it's speaking to the strategy to cancel the use of a panel of attorneys, because what happens is that at this point in time, there is a panel of attorneys whose term is validly coming to an end. So they procured for a certain period, and that period is now coming to an end. There's no basis in law that you have to renew that period. So what happens is that the RAF at the same time is following a new process to get a new panel of attorneys to now replace the old outgoing panel. But that procurement process is what is cancelled. So when we speak of cancellation of panel of attorneys, we're really speaking about the strategy to cancel the use of a panel of attorneys, just in case there may be some confusion around that. So, Chair, to begin by way of background, the RAF has always relied on a panel of attorneys, and it had more than 100 law firms that they appoint through an open tender process, and that's to assist them specifically with claims related matters. So they would attend court proceedings, assist the RAF with settlement negotiations, and deal with claimant attorneys. And this panel of attorneys must be distinguished from the corporate panel of attorneys, because the corporate panel of attorneys would be those attorneys that would assist the RAF in non-claimant related matters. So, for example, the matter related to the AG, that dispute would have been dealt with by the corporate legal services panel. Similarly, that corporate panel would have dealt with labor matters and so on. So there are these two distinct panels, and what we're concerned with is the panel of attorneys in relation to claims. So what the committee heard was that in 2014, the RAF had followed an open tender process to appoint a panel of attorneys to represent it in claims-related matters. And in terms of those SLAs that would have been entered into with that panel, their term was coming to an end in November 2019. So that would mean that you would need to then follow a new tender process if there's a decision that you want to continue having a panel of attorneys. In the 2019-2020 financial year, Mr. Litswalo, then in his capacity as acting CEO, conducts a review of the affairs of the RAF and its operating models. And one of the aims of that review was to reduce legal costs. And this issue of the reduction of legal costs was something that we've heard quite a bit about. It was an issue that the board raised, and the board had indicated, there was a ministerial directive on this. And we went back into the records, and we found that when the then Minister, Mr. Fikile Mbalula, announced the appointment of the new RAF board in December 2019, he raises this issue very sharply about building internal legal capacity. And already at that point speaks about the fact that this may involve insourcing of legal work and directly employing attorneys to process the caseload. And he says that that may save the RAF 2.9 billion per annum, and that there is a model that the legal aid board employed to bring down costs and improve efficiency. So clearly there was already a strategic directive at this point in time that legal costs must be reduced. The RAF management concludes then that the model of using a panel of attorneys is financially inefficient, and they resolve that upon the expiry of that 2014 panel, they wouldn't appoint a new panel. And instead, the decision is that they would hire additional attorneys onto their own staff, who in turn now would represent the RAF in court proceedings. As I indicated, that panel was going to the existing panels service period would have lapsed in November 2019, but it was extended until 31 May 2020 to allow for time now to implement this new operating model. But in the background, what you have happening is that prior to the strategic decision being taken, there had already been a new tender that was advertised to appoint the new panel of attorneys. And this is routine in SCM matters. At the moment you have one contract coming to an end, your SCM function would kick in to ensure that there's no gap, and they would start the advertising of a new tender process. And this is what happens here. The bid adjudication committee was quite far in this process of adjudicating the bids, and this tender then gets cancelled. So when the tender is cancelled in 2019, the RAF issues what they called handover notices in February to all the existing panel attorneys for the return of files, because obviously these attorneys would be sitting with all claimant files, and they want those back so that they can take over. And the notices require an earlier handover of trial matters, because those are your imminent matters that are in court, and particularly for matters that were set down between the 1st of June and the 31st of December. So the RAF is obviously aware at this point that those are their priority matters. They also write to the judiciary at this point, and the RAF CEO states that some law firms refused to hand over the said files. There was court action in which they sought to interdict the return of files, and that was unsuccessful. Notwithstanding, the RAF then still continued to face challenges in respect of the return of those files. And obviously, if you don't have the files, you don't have the updates, it then makes it very difficult for somebody else to take over that matter. The RAF furnished the committee with a document containing a list of 82 of those law firms that refused to hand over the files. And the RAF states that the refusal was not based on any payment conditions. Rather, it was the fact that they contested the cancelling of the attender to appoint a new panel and the permitting of the SLA to lapse through an inflection of time. It was the view of some attorneys that was unlawful and irrational. The committee is obviously well aware of the fact that you have many law firms that exclusively do RAF work. So if you're now taking away the RAF work, that's going to then fundamentally impact on the business of that law firm. When the panel was discontinued, the RAF then moves to a new litigation model, which is focused on the use of the Office of the State Attorney, who then represents the RAF instead of the panel of attorneys. And in order to effect this, the Minister of Justice and the Minister of Transport finalize an arrangement in terms of which the RAF pays to employ these attorneys, but they are then seconded to the Office of the State Attorney. And the purpose of that secondment is simply because an attorney who works in-house, so for example, somebody like myself who's a legal advisor in Parliament, I don't have right to appear in court, so I wouldn't be able to appear in court on behalf of Parliament. And similarly, a lawyer employed by the RAF is not able to appear in court on behalf of the RAF. That doesn't mean to say that the person can't get right of appearance. If I were to move to a private law firm tomorrow, I would have right of appearance because obviously I'm qualified and I passed the necessary examination. So what the arrangement simply was is that we will hire these persons, we will pay for them, we will cover their salaries and so on. They will be based in our office. But in terms of the secondment arrangement, they will be seconded to the Office of the State Attorney because that then allows them to have a right of appearance. The State Attorney, those attorneys are not considered in-house attorneys like the rest of us that work for organs of state. By September 2020, the first cohort of 62 attorneys had been employed, and this is a number that we had confirmed during the SIU presentation in the first week. And the RAF used in-house legal services and these state attorneys to represent the fund now exclusively in court. This was a sharp decline in the number of attorneys that were previously performing RAF work. As we indicated, there were over 100 law firms, and I think it would be safe to presume that in each of those firms, you would have at least 4 attorneys dealing with RAF matters. So that would give you 400 attorneys. And then also they would have necessary administrative support. So your legal secretaries, your admin staff, people that would deliver things to court and so on. Notwithstanding saying, it's now replaced by these 62 state attorneys who now have to cover that same workload. In addition, you have the problem that the handing over of these files is complex, and it obviously leads to delays. And one of the examples that was cited was that medico-legal experts had been deposed. In other words, they had signed their affidavits and they had pleaded for trial by an attorney, and now you're now handing over that matter to a new attorney who doesn't have that prior knowledge or background. And this then creates a bottleneck in terms of processing the matters for either settlement or those court appearances. The first witness that appeared before the committee that spoke on these issues, and that was particularly in relation to the procurement of the panel of attorneys and the cancellation of the tender, was Mr. John Modise. He was a former RAF senior manager for procurement excellence and governance, and he had also acted on occasion as the acting general manager for SCM. Mr. Modise testified that Mr. Letswalo had expressed himself verbally on his intention to do away with the panel of attorneys, and this was in a meeting held in December 2019. And the purpose of the meeting at that point is because, as I indicated, we had the minister introducing the new board, and the minister had made a number of remarks, including the fact that one of the focus areas for the new board would be SCM. And Mr. Modise had explained to the committee that he was a little bit worried about what this entailed and what the issue was. He wasn't aware of there being any supply chain management issues. So he thought it was important that they then meet with Mr. Letswalo to try and unpack the minister's statement and see what needed to be done. And this is what leads to that meeting on 13th of December. And during that meeting, the minutes reflect that Mr. Letswalo makes a statement along the lines of, we need to do away with the panel of attorneys. We do not need them. We will insource. So clearly there is some strategic move to doing away with the panel of attorneys. But at this point, nothing is in writing. There are no clear directives or anything of the sort. One of the reasons that Mr. Letswalo raises is the fact that these attorneys are overcharging the RAF, and insourcing would therefore be a means of cost containment. And he cites an example of the fact that the RAF is paying an amount of R4 per page for photocopying in terms of those SLAs. And obviously there would be cost savings then if they could do this work themselves. Following that meeting, Mr. Modise and Mr. Victor Songilwa, at that point is acting CFO, received an instruction in February 2020 that they ought to draft a cancellation letter to all bidders informing them that the tender was cancelled. As I indicated, that tender process was already quite far advanced, but at that point the tender hadn't been awarded because there was a technical issue that the bid adjudication committee had sought a legal opinion on. And whilst waiting for that opinion, this is when this email is provided to them, and they asked to draft a letter about the cancellation, and Mr. Letswalo also asks for information on when the bid validity period was meant to lapse. So the bid validity period, it's a technical matter, but it refers to a period where a bidder submits a tender and that pricing is then valid for a particular amount of time. So let's say, for example, the bid validity period is 3 months. It then means that an institution must finalize the tender process within 3 months, because otherwise that pricing is no longer valid. It's a means simply of ensuring that organs of state deal with tender processes timelessly, because you don't want a situation where somebody's given you pricing and the award is only made a year later, but then circumstances have changed and that service provider can no longer meet those pricing as submitted. He then also indicated in the same mail that they would need all of these files specifically for the trial dates, and they would need to try to do some block settlements. Mr. Modise was extensively questioned on the process to be followed in respect of a cancellation of a tender. So in other words, was it in order that they simply received an email from the acting CEO indicating that the tender had to be cancelled? And he testified in summary that the RAF may lawfully cancel a tender before awarding if there are legitimate reasons. And some of the reasons he cited would be a lack of budget, non-responsive bids, where bids are above market price, where there are material governance issues in the way in which that tender matter had been dealt with, and where there's a change in need, where the business unit no longer needs the services or goods required, or the tender scope were to change drastically. So an example would be where COVID hits and we've done a tender, for example, to procure bottles of water for members of parliament for committee meetings. Obviously, you're now no longer having in-person meetings, so you no longer need those bottles of water. So what you then do is you cancel the tender because of the change of circumstances. And his evidence accords to what the preferential procurement regulations provide, because those regulations provide the legal basis on which an award or a tender process may be cancelled. So according to Mr. Modise, in terms of their process, the onus would be on the relevant business unit to submit such a request, because obviously the business unit would know the reasons as to why, and would be able to justify why a tender should be cancelled, because in law you would have to show that justification. And the bid adjudication committee would then have to consider and approve that request for cancellation. There's obviously cost implications. There are obviously possible legal implications if such a cancellation were to be challenged, which is why there are these different processes then in place to make sure that there are sound legal reasons for the cancellation. The RAF then has to publish notice of the cancellation, and bidders would have also then been individually notified in writing about the cancellation. So prior to this email being received, Mr. Modise testified that he wasn't aware of any decision or instruction to cancel the tender process, which was, as indicated already, at a very advanced stage. And in fact, at this point, he had just increased the validity period of the bids. As indicated, had that not been done, then that pricing wouldn't have been valid any longer, and the entire tender process would have collapsed. And in order to ensure that there wasn't a lapsing, he provided notice to bidders on 16th of January already, pending the finalization of the adjudication process, to inform them that the tender validity period would be extended. And this was painted to us as a routine matter where a bid is going to expire in terms of the pricing. It would be necessary to ensure that that validity period is extended so that the tender can be kept alive. And members may recall that Mr. Modise had said that there were previously cases where SCM staff had failed to do that and were then disciplined for that failure. Because obviously, if a tender process collapses, it then has adverse financial and practical consequences, and there needs to be some accountability that follows. So because of the fact that you had the BAC awaiting this legal opinion, the process isn't finalized as quickly as they had originally anticipated, and it became necessary for Mr. Modise then to take that step to extend that validity period. Following the email from Mr. Letswalo on 13th of February 2020, a special bid adjudication meeting is held, and that culminates in a memorandum then formally being sent to SCM, wherein Ms. Chabavu then requests SCM to cancel the tender, citing unaffordability and the decision to handle the litigation in-house. So this is the first time that there's formal notice to SCM that they should cancel, because on Mr. Modise's evidence, the mere fact that there was an email from Mr. Letswalo would not have sufficed. However, prior to SCM then being able to action this request or otherwise deal with the request and consider whether there were sound legal reasons for the cancellation, Mr. Modise gets summarily suspended on grounds of gross negligence and gross insubordination in relation to that earlier action of extending the tender's validity period. So what happens is that he is served with a letter of intention to suspend him, and the grounds raised therein is that he failed to obey a reasonable and lawful instruction that had emanated from Swallow during that December 2019 meeting, meaning the meeting that he himself had requested. And that was the meeting where, as I indicated, Mr. Swallow had said that, they want to do away with the panel of attorneys and source in-house legal services. So in his testimony, he alleges that this happens now, notwithstanding the fact that at that stage in December, and even at the point where he extends the validity period, there is nothing formal in writing in terms of an instruction to cancel that tender process. If they were, then obviously it would not have been necessary to extend the period. And he says, but in any event, even if it had been, it would have been irregular and unlawful, because discontinuing a major procurement process like the panel tender in such a manner and without board approval would violate their internal delegation of authority and their own SCM policies and procedures. So according to him, it wouldn't have even sufficed simply for the bid adjudication committee to instruct SCM to withdraw, but it would have actually been a matter that the board would have had to consider, and that would have been in terms of their own internal governance process. The committee then sought to ascertain from other witnesses what the rationale and process was to terminate the panel of attorneys, which ended on 31 May 2020. So that was the last day of the existing panel, the outgoing panel, and whether that decision was made with regard to the RAF's highly litigious nature, which is not in dispute, and whether there were any viable alternate arrangements in place to deal with the inevitable service vacuum that would now be created. And the SIU appeared before the committee in the first week of our inquiry, and they noted that the rationale of the decision that was investigated by themselves, and that the decision not to proceed was not approved by the board. Safe to say the board approved a strategy wherein the RAF had to reduce its administration costs, including legal costs. So in short, what the SIU was saying is that there's nothing in writing where you have the board saying, please cancel, or we authorize the cancellation of that tender process. Rather, there is this overarching decision in terms of strategy that we need to cut legal costs. But the board doesn't drill down into how those legal costs must be cut, and they don't give any clear directives, or there's no decision that's recorded in writing specifically on the issue on the cancellation of that panel of attorneys tender, and the decision then not to use a panel of attorneys going forward. And what the SIU presented was corroborated during the inquiry by other witnesses. Former board members, from their testimony, it was clear that they were aware and therefore must have implicitly endorsed the decision to move to an insourcing model as a cost-saving strategy. But bizarrely, they do so without explicitly approving the cancellation of the panel of attorneys tender, notwithstanding that at all material times it appeared that the board was in fact aware that there was this tender. According to Mr. Nyama, who was a former board member that appeared before the committee, the issue about the panel of attorneys was one of the most complex and difficult decisions. And if memory serves him correctly, they were concerned about what they called day zero, meaning the day in which that money hits your bank account, attachments are more than that money, and the RAF therefore can't continue to function. So they were aware of the fact that it would be necessary to reduce operating costs, including legal costs. And he says there was an assessment on that aspect, and if he recalls correctly, management had demonstrated that they're able to save a certain amount of money in the region of 20 or 25% per annum. so that they could then free up those funds then to pay claimants. Again, he speaks of the fact that he was aware that there was a tender for a panel of attorneys because the existing one was expiring, and there was some sort of high-level transitional plan. He says it was clear that this plan required more working, and obviously they had to make sure that at the end of the day, from an execution point of view, the claimant should not suffer. So really, really broad brush strokes, because he recalls the fact that the tender period was extended, or rather the service period for the existing panel of attorneys was extended for 6 months. They recall that there was a new tender, but they don't seem to have any recollection in respect of the fact that that tender then would have needed board approval to be cancelled. Mr. Nyama's version is then supported by Dr. Mabuya Molela, who stated, and she was also a board member, that she knew that the actual contract had expired and that the board had said that there must be another RFQ. It says RQF, but it would have been an RFQ process that must be followed, and they must look for another. But the interim was really an issue, and it was a challenge. And they were then informed that the fallback plan was that there would be reliance on this internal panel of attorneys through the state attorney model. So again, you can see that the board is aware of the fact that in the background you have this tender, but for some odd reason there does not seem to be any clear decision then taken in writing that the board is now drilling down into this and making a decision that that tender process be cancelled, and these are the stopgap measures that are going to be put into place, and this is how the RAF is going to deal with the vacuum that will be created by the fact that there is no panel of attorneys. On the contrary, it seems to have rather been fairly broad discussions around the fact that the RAF had to start saving costs, and I don't think there's any dispute that those costs had spiraled, and there was definitely a need to curtail costs where possible. But as indicated, there's no evidence that the board actually applies its mind properly to the decision. So the SIU found that there was no proper plan in place to replace this panel of attorneys, notwithstanding that Mr. Letswala's version was that the RAF was going to employ legal practitioners and second them to the state attorney. In the view of the SIU, this was a mere ex post facto afterthought. So in other words, it was not part of any proper planning process where somebody sat down and crunched the numbers as to what would be required in order to replace that 100 plus law firms now with the necessary warm bodies to do the work. In the view of the SIU, RAF management had acted irrationally by presenting a report to the board without having any proper plan in place. And the board, in turn, as the accounting authority, also acted irrationally by approving a cost-saving strategy without any corresponding plan to deal with the work entrusted to the panel of attorneys, including the handover process for all of these files that would have been sitting with those attorneys. The SIU explained to the committee that in their view, the lack of this proper planning caused an increase then in default judgments, and the total amount of default judgments issued against the RAF for cost and fees from 2018 until the end of the second quarter in 2023 amounted to a staggering 4.78 billion. The committee then heard evidence from Mr. Songelwa and Mr. Itai Charakupa. He was the former senior manager in the actuarial unit. And the committee will be aware of the fact that both of these gentlemen had very long, substantive, detailed technical affidavits that deal with the financial effect of this decision. They both testified that the intended savings, because they were savings, but that these savings were negated by a sharp rise in the average cost per claim and the resultant default judgments. So according to their testimony, the combination of inflated settlements and default judgments contributed to the 70% increase in the average cost of a single claim. So where you have a situation where there's no attorney to defend an inflated claim, a judge will simply award that claim. So if the matter is in court and there's nobody there to say that person X should not be paid R1 million for the injury suffered, and these are the reasons why that amount is inflated, a judge, without having had the benefit of that counter argument, would simply have to make the award. So according to Mr. Songelwa, he said that any saving on legal costs was merely an illusion, because the expenditure of legal expenditure may have decreased by about 5.85 billion in the 2020-2021 year. But in the same period, you had excessive claim settlement costs due to the undefended or underdefended claims. So the one really cancels the other out. We've then included an infographic that was used to illustrate that the cancellation of the panel of attorneys resulted in that increased average value per claim, which was a 70.4% increase. And obviously that can't simply be attributed to inflation. That amount is simply far too high for that. Mr. Charakupa also testified that on his own analysis on the impact of the termination is that it may have created room for fraudulent claims, and obviously also inflated claims or even claims relating to injuries not sustained in a motor vehicle accident, because you now have a situation where the claims are not being properly defended. They may simply be sitting on a desk, and then the matter goes to court, but because there's no attorney involved to actually check the status of that matter and whether it is a genuine matter, you may then inadvertently be allowing fraudulent claims to enter the system. I think that's always been an issue at the RAF, where people made attempts to claim fraudulently, but you would have had to have measures in place to prevent those claims from processing further. And without the panel of attorneys, you then have that gap being created. The committee also heard quite a bit on the issue of the panel of attorneys from Ms. Christina Mtetwa, who we dealt with in the previous section. So when the direct claims sections are dissolved, something quite strange happens. You have Ms. Christina Mtetwa then being seconded to the Johannesburg branch to act as a senior manager litigation and to help manage the litigious claims following the termination of the panel of attorneys. And the reason why I cite it as strange is because the committee would have heard from Ms. Mtetwa that she didn't have legal qualifications at the time of her secondment. She came into the post with no legal background, no prior experience in litigation, but that she was put there based on her managerial experience, which the committee obviously doesn't deny. It was clear, I think, from her testimony that she was a very experienced and competent manager who would have been able to lead that team. But it is a rather strange turn of events that you would now have a person that has no legal background being tasked with heading this litigation unit. She was, however, told that she would be given the necessary support in handling litigation-related matters. So now the committee can now see how these decisions are all happening at the same time, and each one has a bearing on the next. So direct claims and the dismantling of that strategy then also becomes linked to this issue of the cancellation of the panel attorneys. So according to Ms. Mtetwa, one of her duties included reviewing and authorizing settlement offers, and she had a delegation there of 3 million. And she was also tasked with managing litigation risks and the default judgments and supervising the work of claim handlers. She said that when she arrived, it was chaos. She said her mandate was 3 million, and that's what she had to commit herself to. But if there was anything above that 3 million mark, then she needed to support the request, and it would go to the highest authority. If I recall correctly, those files would then have to be transferred for approval to the head office. And there were piles and piles of files now waiting for these mandates to be signed so that an offer can be issued. And obviously, where you have a situation where an offer can't be issued or hasn't been issued, you may then be going dangerously close to that prescription period, and that's then going to obviously lead to summonses being issued to interrupt that period. She called that office chaotic and disorganized. She had indicated that the claim handlers inherited tens of thousands of active court cases, and each claim handler managed over 1,500 active files with over 300 daily inquiries. So that would be a single person. These claim handlers are left without support structures. They were expected to assess files, issue offers, and simultaneously handle the litigation aspect and the matters going to trial. And we will deal with some of this in the labour section, Chairperson, because you will recall that Ms. Mtetwa had also said to us that, it really wasn't humanly possible for these claim handlers to manage this workload. And where they were unable to do so, many of them were then subsequently disciplined, notwithstanding the fact that they didn't have the necessary resources to assist them, and they were clearly overworked. She indicated that there were no dedicated teams or mechanisms in place for trial matters, and no means of responding to summonses. And she said that there were even summonses on their desk that they had not looked at for years, some as old as 5 years. Meanwhile, on the other side of the coin, you have plaintiff attorneys who are actively managing their clients' claims. But on the flip side, you have the RAF attorneys simply not able to manage all of these claims. By the time she and her team tried to negotiate with attorneys on such a matter, the summons is already undefended, and that leaves the RAF in a very weak legal position, because an attorney then knows, I don't need to agree to a settlement because it would be in our favor if the matter had to go to court because it is undefended. In respect of the new state attorney model, Ms. Mtetwa testified that when she arrived in Johannesburg, some of those state attorneys were already there, and I presume that would have been those 62 attorneys that we spoke of earlier. And she was told that they didn't yet have right of appearance in court. And of course, that right of appearance would have been necessary from a legal perspective for those attorneys to appear in court. And the delay might have been occasioned by the fact that there would have had to have been this secondment arrangement. But this happens already a year post the panel being terminated. So you have a period of a year now, according to Ms. Mtetwa, where you don't have attorneys that have the necessary right of appearance. And according to her, some judges allowed these attorneys to proceed, notwithstanding the fact that they don't have this formal right of appearance. And that was something that also cropped up in public submissions, where there were allegations that there were RAF attorneys attending court without the necessary right of appearance. And it really then becomes a catch-22 situation, because if you don't attend court, the outcome is going to be far worse, most likely, than if you were to attend court. So it appears that some of these attorneys then made the decision that they would attend court in any event, notwithstanding that legally they should not have done so. And that obviously, Chair, would have also had huge risk implications for those individual attorneys to do that. Ms. Mtetwa also testified that numerous court cases were then not attended to properly, resulting in the default judgment, something that was confirmed by other witnesses. That these claim settlements then get unreasonably delayed because of the backlog and the fact that she has to wait for authorization and settlement in amounts exceeding 3 million. And she says that these delayed payments, the default judgments, all resulted from operational overload, staff shortage, and the absence of the panel of attorneys. So clearly there wasn't a plan in place to deal with those gaps. The committee then heard from Mr. Brett Phillips, who worked with Ms. Mtetwa. She's actually the person that employed him. Mr. Phillips is currently the senior manager for litigation and mediation based in Johannesburg, and his role is effectively to supervise and oversee the state attorneys and to manage the arrangement between the RAF and the Office of the Solicitor General. So Mr. Phillips confirmed that the state attorneys are indeed employees of the RAF and that their salaries are paid by the fund. but that there is this secondment arrangement to secure the necessary right of appearance. And he testifies that when he arrived in Johannesburg in November 2021, his primary goal was to settle as many matters as possible for fair and equitable compensation while still attending to matters that had genuine legal disputes. However, around May 2022, a management directive was issued requiring that all matters be defended. And he testified that attempts were still, however, being made to settle matters, as that was first prize. But of course, you now have a directive saying defend every matter in the face of the fact that you don't have sufficient attorneys to deal with it. And this obviously marks a significant change in how litigation is then managed. He says that when he arrived, there were initially 10 state attorneys and they were handling matters virtually. And in his recollection, there was a fuller return to in-person court proceedings around 2022. And the capacity at this time is then gradually being increased. Currently, as it stands, he oversees 105 state attorneys. I know he did indicate that he was going to employ, I think, another 4 more, if I'm not mistaken, in the near future. That may have been done already. And these 105 state attorneys serve 13 regional offices, but the organizational structure provides for 353 positions. But according to him, there is a moratorium on the filling of vacancies due to the fact that there was, or still currently is, a restructuring process underway. So according to his, what he called rough calculations, his department has provision for 216 state attorneys, 184 of which would be used for high court matters, and the balance of 32 for the magistrates court. And based on the estimate of there being 252,000 active matters, he indicated that in his view, a manageable file count would be 600 to 700 per attorney, meaning that the department is at least 204 state attorneys short. He also, when questioned on the amount of files that these attorneys are dealing with, said that it varies from region to region, with the smaller regions having smaller caseloads, but in the larger regions, it can go upwards of 4,000. So members, that would be one single state attorney having to deal with 4,000 case files and being responsible for that. He explained to the committee that the instructions to the state attorney who attend to that matters comes from claims operations, and that they do have a litigation management system, so an online system in place. And the instruction then originates from whichever department in operations requires services from the state attorneys. And the committee then sought to understand, well, if there is this litigation management system in place and a system for these instructions to flow, why is it that you end up with a situation where some matters are not defended in court? And we try to drill down into whether there's somebody that actually has overall responsibility for litigation matters. So from the point that a matter becomes litigious right up until the point that the matter is finalized. And he testifies that the reason why these matters are not defended in court is capacity related. So he doesn't then give a definitive answer to who must take overall responsibility. But he does mention the fact that that system, that LMS litigation management system, is really not fit for purpose. So that system is not working the way it should work, but the department is planning to procure an end-to-end system that will allow for the dashboard showing how many matters there are, when the matters are going to trial, who the attorneys are that are assigned to those matters. So currently it appears that there isn't any proper system in place to manage those caseloads. Mr. Phillips indicated that he reports to the chief governance officer. So that would be the person who takes overall responsibility of that section. But of course, this is not then the person that deals with the nitty-gritty of the litigation. So that reporting is very broad in nature, and in reality, there's no person who manages the overall allocation of matters and caseloads that any given attorney would need to defend in respect of the court role. So you said that the way in which the system is configured at the moment, we don't necessarily have a globular view. And that was something that members would have observed during the oversight visit as well. I know myself and the researchers had a meeting with some of the state attorneys to try and ascertain how it is that they come to know where they must be and what that they must do. And clearly there isn't an online system that paints a clear picture or a globular view, as Mr. Phillips referred to it. Ms. Mampe Kumalo, who is the Chief Governance Officer, was also questioned about the monitoring of caseloads. And she noted that in terms of monitoring caseloads in court proceedings, they have court monitors at certain courts to monitor the court rolls. And so court rolls really tell you which matters are in court on a particular day. Often those rolls are simply stuck on the outside of a courtroom and they list all the matters. And therefore, those court monitors in turn would inform her senior manager, now Mr. Phillips, to then be able to provide instructions to the state attorneys. And she says that these court monitors are given access to the court online system so that they can see which matters the RAF needs to be in court on in the respect of a particular week. So Mr. Phillips, as far as I recall, Chair, didn't deal with these court monitors. She also mentioned the LMS system. And she did note, however, in accordance with what Mr. Phillips said, that they are aware that the system is not as effective as they would like it to be, and that's why they're in the process of procuring a new system. But according to her, there is a system. I think Mr. Phillips' evidence was a little bit stronger in the respect of the fact that that system is not fit for purpose. Mr. Phillips' testimony corroborated broader evidence presented to the committee regarding the impact of the decision to discontinue with the panel, which obviously then left this huge void in legal representation. This lack of capacity has resulted in, and it continues to create a situation where attorneys are scheduled for multiple trials on the same day, and this obviously severely hinders the RAF's ability to manage its legal workload. This concern was also raised by state attorneys who the committee interacted with during the oversight visit to the RAF's offices. So they showed us how they were expected to be in court on multiple matters on the same day. The former RAF board members were also engaged on the issue of the decision to do away with the panel of attorneys and whether they had properly considered and implemented the decision. And in their testimony, they acknowledged the challenges that arose due to the cancellation. According to Dr. Mabuya Molele, in her recollection, it took 6 to 9 months before that state attorney model kicked in, which created problems because the RAF then solely relied on the internal corporate panel of attorneys as a stopgap measure. So, Chair, we don't have more evidence on the use of the corporate panel. But what would be strange is the fact that that corporate panel would have been procured only to provide corporate legal services. So it's unclear on what basis the corporate panel, if they were indeed used to assist with claims, would have been legally able to do so, because that would have not have been the purpose for which they would have initially been procured. The board, however, maintained that they always acted in good faith and they placed reliance on representation by management. And they viewed the new operating model as a necessary step towards financial sustainability and to avoid the eventuality of day zero, a scenario which an already underfunded RAF becomes insolvent and then is unable to meet its financial obligations. So their concern was broader in nature, that they needed to do whatever was necessary for the RAF to save money. When the interim board appeared before the committee, the chairperson of the board, Mr. Brown, indicated that notwithstanding the fact that the board had been informed by state attorneys employed at the RAF that the model was working, the board questioned this. And it was noted by the board that when you look at the court roll and the growing default judgments, that you can't say that the system is working. You can't draw that conclusion. And they thought that the system would have contained that, but at the end of the day, it isn't containing it. So the legal operations team was expected on the 20th of February. It's obviously a date that has passed, to come up with a proposal as to whether the RAF should proceed with the state attorney model. Should they move to a hybrid? Are they going to bring the panel back so that there's a structured way of dealing with this? And Chair, at this point, I just also want to note that the state attorneys that we had spoken to during the oversight visit also spoke in support of the state attorney model and the fact that in their view, the model could work. However, it really boils down to the fact that there isn't sufficient resources. And this accords with what the interim board then also indicated. According to the board report, the RAF's claim management was not supported by strong legal and governance capability, and the value of default court judgments over the last 4 years stands at about 15.7 billion. And this contributes significantly to the financial stress of the RAF. So clearly the decision to do away with the panel of attorneys in order to save money has in some ways now backfired. In addition, the committee then also heard evidence in respect of the impact of the cancellation on medical legal service providers. Ms. Botbeel, who deals with debt collection matters on behalf of medical legal experts, submitted an affidavit, and according to her, there was no concrete plan put into place for how medical experts would now engage with the RAF. One, for them to receive the necessary information that they needed in order to perform their duties and to draft that report, because prior to this, they would have been getting instructions via an attorney. So there leaves that communication gap now. And then you also have compounded on that is the fact that these medical experts are not merely now chasing payment any longer, but also just basic instructions and information required for them to perform their services. And where you have a case of a medical expert not being able to provide a proper, meaningful report, you're obviously going to have then a negative impact on claimants, because that report is fundamental and instrumental to proper offers being made and for the court to able to properly deal with issues of quantum. She said that it was not uncommon amongst her own clients that victims of road accidents would arrive for consultations, but the medical experts wouldn't have received vendor rotation numbers because these medical experts were now being procured directly by the RAF. And she spoke at some length about the fact that the RAF hasn't actually properly procured these people. They can't make sense of the fact whether they are on a panel of medical experts or they're not on a panel of medical experts, but often they don't want to risk non-payment. And so in the absence of those VRS numbers, they would be forced to turn these victims away. She says that at the time that the panel gets cancelled, you still have a situation where medical practitioners are owed money for services that they've already rendered. And even though that procurement arrangement would have been between the panel attorney and the medical expert, the service itself would have been for the benefit of the RAF. But the RAF doesn't put in place anything to deal with a vacuum that would now be created. In some cases, you have attorneys actually shutting their doors, or they can't get hold of these attorneys, especially where you had attorneys that were solely doing RAF work, that business model. They weren't able to sustain it any longer. They closed their doors, and now you have a situation where your medical practitioners haven't been paid, notwithstanding that if there was a transfer of the file, the RAF would then still be making use of those medical legal reports. So according to her, there appeared to have been no plan in place to deal with the impact on medical legal experts, including the fact that there was no plan on how payment should work. And she details in her affidavit and also during her testimony the various attempts that were made by medical practitioners to try and resolve the issue. And what appears to have transpired now is that the RAF now claims that there is a prescription of those claims for payment. So because these medical doctors have not taken steps to try and disrupt that prescription period by issuing summons and taking legal action against the RAF, that in fact the claim now no longer exists in law, and so they're not going to be paid. And she painted a picture of this being a very disingenuous way of dealing with them, notwithstanding the fact that prior to this, it seemed that the RAF was sympathetic to the plight of these medical practitioners and had undertaken to try to assist and put things in place to help them. So one of the things they were, for example, promised was that the new claims management system would allow these medical practitioners to access claimant information, to have the necessary information to draft the reports, to be able to look at other reports, to see where the payment has been made, and so on. And none of that has actually transpired. In terms of observations and finding, the first thing, and it's very important that we set this out, is that the committee recognizes the right of the RAF board and management, obviously subject to compliance with their own internal procedures, to determine the most efficient and cost-effective manner to reduce legal costs. So the committee cannot and will not make comments or findings in respect of whether the RAF should utilize a panel of attorneys or utilize an insourcing method for doing its legal work. It really is neither here nor there in respect of the issues at hand that the committee needs to apply its mind to, which is simply whether this decision was taken in a rational manner and whether the decision has adverse financial consequences for the RAF. It's obvious that the same decision could have been taken, but had there been due regard to planning and so on, it could have been done in such a way where you wouldn't have seen this rise in default judgments and all of these service gaps. So the committee's interest is whether these strategic decisions are implemented in a manner that ensures operational effectiveness and efficiency and does not result in wasted costs. So the committee notes that board and management have a fiduciary responsibility to take and implement decisions responsibly and with the necessary information at its disposal to ensure that this ultimate, which is a noble goal of cost savings, is actually met in reality. So based on the information available to the committee notes that although escalating legal costs were touted as the primary reason for the decision to dispense with the panel, there was in fact no plan in place to deal with the gaps that would be created by the decision. Whilst the board approved the strategy to reduce legal costs, and that was in line with the sentiment shared by the minister, there is no evidence that any cost-benefit analysis was undertaken, that there was any clear implementation plan on how the services which were performed by those outsourced attorneys would be delivered going forward, and what the practical implications of such a decision would be. So this is quite similar to what we dealt with in respect of the direct claims issue, that these strategic decisions seem to be taken without having all the necessary information and plans and processes in place. Had proper consideration been given to the decision, it ought to have easily become apparent that it could not be immediately implemented without the benefit of a transitional plan. And it should have been obvious that that plan should have at least recorded which cases were due in court in the foreseeable future, the stage of litigation of each, and whether such cases could realistically now be taken over by the state attorneys and still allow them sufficient time to prepare for court. So are your 62 attorneys prior to that, just a handful of attorneys, going to be sufficient to deal with the current caseload? Whilst the former board emphasizes that they always acted in good faith and on the strength of representations from management, it's clear that they failed to fully interrogate the implication of their strategic approval to save legal costs. There is no record of the board formally engaging, or formally approving rather, the cancellation of the tender, and no interrogation of the impact of same, notwithstanding that the board was at all material times aware of the cancellation. They would have had to have been aware that that tender was going to be cancelled and that there was a movement now towards the state attorney model. The result of the above is that the panel of attorneys is abruptly halted without any clear plans in place. And this is borne out by the fact that Ms. Mtetwa and the committee commends her for the efforts she tries to make in that new role that she's seconded to, is appointed to a post without the necessary legal qualifications and without the necessary staff complement and with no systems in place. Yet she's expected to fulfill the role that the panel of attorneys would have performed. In addition, Mr. Phillips is only appointed approximately a year after the decision to dispense with the panel of attorneys, and he continues now more than 4 years later to be plagued by severe human resource challenges and the lack of a fit-for-purpose case management system. So it really isn't even a case that they just needed a few months and these were teething issues. It's now more than 4 years later, and the very same issues which plagued the fund at the start when the decision was made continues to plague them. Furthermore, there was an unacceptable delay in legal representation for at least 9 months before the state attorney model kicked in, which created a significant vacuum which persists, notwithstanding the introduction of the state attorney model, because there are still these ongoing capacity issues. The fact that the RAF had to make use of the internal corporate panel of attorneys is further indicative that there was no plan in place, because that really does beg the question that if there was then still a need to use outsourced attorneys, why not simply allow an extension of the period in respect of the existing panel of attorneys? That would have saved, from a practical perspective, the RAF, in that you wouldn't have had this issue about the transfer of files and so on. So the internal corporate panel was obviously also insufficient to handle the high volume of cases previously handled by the panel of attorneys, which would have been a far bigger panel. And as I indicated, it's not even clear in any event on what the legal basis would have been to utilize that panel. The lack of proper planning has resulted in an untenable situation where 62 attorneys, as opposed to more than 100 law firms comprising of several attorneys supported by administrative staff, are expected to contend with the entire RAF caseload. The fact that there are state attorneys with upward of 4,000 matters means that no meaningful attention can be given to all of those matters. The mind boggles to think how it would be possible for any one single attorney to have such a large caseload on their desks. And to exacerbate the matter, they don't even have access to a reliable or fit-for-purpose litigation management system. So it's very much clear that the internal legal capacity is insufficient to absorb the volume and complexity of the litigation that would have previously been handled by the panel. This has resulted in an increase in default judgments and court matters being struck from the roll with punitive costs due to the RAF's inability to properly prepare for trials and defend claims. And the escalation in default court judgments contributes significantly to the financial stress of the RAF. The combined value of default court judgments against the RAF for the past 4 years, as I indicated earlier, stood at 15.7 billion. And in respect of the 2024-2025 financial year, which is our most recent financial year, it was at 6.6 billion. Judging by current trends, the estimated cost is estimated to be much higher than even in previous financial years, and it probably will climb. In addition, the RAF has clogged court rolls and earned the ire of the judiciary. Members need only read some of the judgments which involve the RAF. It's clear the judiciary is not satisfied with the situation at all, particularly in Gauteng. The Judge President of the High Court in Johannesburg in March 2024 addressed a letter to the legal profession in which he tried to address the huge backlog of the RAF. And he made several disparaging remarks, saying that they're totally ignorant of the case and incapable of engaging even in settlement discussions, and thereupon files belated notices of oppositions. One acting judge recently informed me that his entire role had been sabotaged by this ruse. I need not belabor the unethical nature of this conduct. It makes a mockery of the court process. So those are very harsh words. And it is unfortunate that the small group of clearly overworked state attorneys who are working without the necessary resources are now being painted with a brush that depicts them as unethical or and incompetent, whereas the root cause obviously lies with the RAF itself. And Mr. Phillips went at some length to speak about the fact that he has very, very competent state attorneys. But unfortunately, irrespective of how competent one may be, your environment also needs to be fit for purpose. Otherwise, you're fighting a never-ending battle that you can't win. So notwithstanding the above, the committee appreciates that there was this delay in retrieving RAF files from the panel of attorneys, and this obviously would have exacerbated the challenge of undefended claims. But this does not detract from the fact that proper planning and stakeholder consultation would have identified most of the problems that eventuated. And also those problems can't be ongoing. Those were a specific number of files that had to be handed over. It doesn't explain all the difficulties that the fund is currently facing. One would have expected that had you had proper planning in place, that that planning would have had ensured that there were proper arrangements for the handover of those files, and that perhaps even those files that were reaching or near to conclusion would have been allowed to be concluded by those attorneys, just so that you prevent the disruption of having a handover of files and a new person now having to take those files over. The committee also notes that whilst medical experts may have been procured by the panel of attorneys, their services were ultimately for the benefit of the RAF, and the RAF ought to have ensured that proper planning was in place to ensure that the outgoing panel of attorneys had settled all accounts. And also obviously the fact that plans should have been put into place to ensure that there were proper communication channels to deal and to give instructions to these medical practitioners in the face of the fact that they no longer had the panel of attorneys as the middleman. In the circumstances, the committee finds that the decision by management, with the knowledge of the former board, to terminate the panel without a project plan, risk identification and mitigation, and a cost-benefit analysis is reckless and grossly negligent. In taking the decision to terminate the panel, the RAF management did not take into account the adverse impact on medical experts, nor did it put into place any measures to address those consequences, thereby negatively impacting on both the experts and claimants. The committee regards the non-payment of medical experts who have legitimately and in good faith provided services for the benefit of the RAF as a serious matter, which is likely to negatively impact on claimants, as it creates a situation where medical experts will be hesitant to perform RAF-related services, which are a necessary and integral part of the claim process. So unfortunately, this process cannot be done without medical experts. The decision has led to unnecessary costs, which in the view of the committee constitutes fruitless and wasteful expenditure, as it could have been avoided had reasonable care been taken. And that is the acid test in terms of the PFMA, whether had proper care been taken, those costs could have been avoided. The fund's average cost of claim settlements escalated by more than 70%, and instead of saving money, the average settlement value of RAF claims skyrocketed, mainly due to large volumes of default judgments and inflated claim settlements, which were incurred by the fund. So in the 2024-2025 financial year, the average value per claim was 348,100 Rand. The committee further finds that Mr. Letswala acted without the necessary authority by directing Mr. Modise and Mr. Songelwa to cancel the tender for the panel, a decision which ought to have expressly been taken by the RAF board. The RAF, now 4 years later, after the decision to terminate the panel, continues to be plagued by lack of capacity and fit-for-purpose litigation management system, which has led to the continued loss of cases, resulting in financial losses, as well as adding strain to the judicial system to the detriment of other litigants. So that's an important aspect, because this decision now has not only impacted claimants and the RAF and the stakeholders in the RAF process, but it also impacts other non-related litigants in the court system, because of the court rolls now being clogged with RAF matters. Notwithstanding same, the former board did not take any concrete steps to mitigate these risks. Such steps may have included, by way of example, the introduction of a hybrid system, which included the use of a panel and in-house attorneys until such time as the state attorney model was fully functional. So it's interesting that the new interim board has now realized that in fact would have been one of the measures that they could have put in place of how to phase in one strategy and then slowly allow the other strategy then to be fully implemented, rather than dealing with a day where you simply cut off the former panel and expect the work to be now done in-house. But as indicated, Chair, it's not the role of the committee to necessarily reflect on whether one system is better than the other, but rather simply the focus is on the fact that in changing the systems, there clearly wasn't any proper plans in place to mitigate the risks, which in turn have led to these financial losses that the committee is seized with. Thank you, Chair.
Thank you very much, Mr. Ibrahim. I hope you'll get a chance to drink some water. Thanks very much. Honorable members, shall we take some comments on this portion of the report? And once we're done, we'll adjourn. I'll take all three in sequence. So Honorable Atkinson first, Honorable Skosana, and Honorable Mende.
Thank you very much, Chair. And again, compliments to those who produced this very, very comprehensive report on the panel of attorneys. I think probably what is most concerning is the fact that the situation continues to persist. So, you know, we're all very much alerted to the situation over the last.
Honorable Atkinson, I can't hear you. Honorable Atkinson? Oh dear. Okay, I wonder what happened to him. Okay, I think he's going to come back. So can we take Honorable Skosana in the meantime? And then we'll get back to him when he reconnects.
Yeah, no, thank you very much, and good afternoon to everyone. You know, we really appreciate the draft report on this portion of our work, and I want to join other members in congratulating our team by compiling such a very comprehensive report that truly represent our engagement with the various witnesses. I think what is important, which is a point that I think Ms. Ibrahim has emphasized, which I think it's a very important point, that one, there seem not to be a formal decision that was taken by the board in relation to the issue of doing away with the panel of attorneys and move to the issue of insourcing, because there were no documents or any sort of written evidence to show that at a certain time there was a meeting where the board took such a decision. So that is very problematic, that such an important decision or such an important action can be done in an organization without a relevant structure like a board taking such a decision. But then, two, as much as the decision was taken maybe by the management or by whoever, with good intentions, as those who were supporting the decision, I think they also came before the committee, and then they raised the issue of high legal cost in relation to the issue of panel of attorneys. And then the intention of moving to doing away with the panel of attorneys was trying to save cost, which from what they were saying, it sounded as a very good intention. However, like the report indicated, that backfired. That backfired because they ended up spending more on legal cost after they dealt away with the panel of attorneys. So there are two issues. One, the issue that there's no there's no proof that there was a formal resolution taken by the board in this regard. But secondly, the fact that this thing ended up backfiring, the good intentions that those who intended, there are those who had a good intention. That thing backfired because then the entity ended up spending more. So I think it's a serious concern on my part. But also we take the point that we can't, as a committee, obviously prescribe to them to say no. You should not. You should continue with insourcing, or you should revert back with the panel of attorneys. I think it's a decision that should be taken by either the interim board or the board that would be the permanent the board that will be appointed in due course. However, I think the worrying factor is the due diligence with regards to this decision being taken. It shows that there was no, if the decision was really taken by the board, maybe just that they don't want to take ownership or whatever, it shows that there was no due diligence in taking that particular decision. And if the decision was taken by the management without the involvement of the board, it's still, then there's also a problem of not involving the board in taking such a good decision. So there should have been a proper process where relevant people in the management participate, but also the board, as the highest decision-making body, is also able to ventilate on this matter and take the decision, but also making sure that there's due diligence. They do their homework and have alternative to say, if we do away with the panel of attorney, are we ready? Do we have structures? Are we going to have enough state attorneys who are going to handle these matters? Are the claim handlers, will the claim handlers also be able to cope with the load? Because it is also being indicated that one claim handler had to be responsible for more than 1,500 cases, which that is unbearable. So there was no due diligence in looking at all those particular matters before they arrived at a decision of doing away with the panel of attorney. And it is not clear as to whether the board, as the highest decision-making body, was involved and formally took a decision to move away with the panel of attorneys and cancel the tender in that particular regard. So I think the report, I think it does, I think to a larger extent, represent what transpired in the committee, the evidence that was put before the committee, and the fact that the point that we are emphasizing is that there was no due diligence in taking that particular decision. Though it is up to them to take that decision, it's not up to us to say which decision was right, but there was no due diligence because RAF as a state entity, it needs to exercise due diligence when they take decisions because they are operating on the public funds. So they can't just take reckless decision, which at the end of the day, taxpayers, people who are contributing those funds are not going to get value for their money. And the road accident victims who are supposed to benefit from the scheme, they end up being compromised and then being prejudiced in the process. So I think really the report, I think it does cover that to the large extent. Thank you very much.
Thank you very much, Honorable Skosana. Honorable Mandy, I'll come back to you, Honorable Atkinson, so that you can finish. Honorable Mandy.
Thanks, Chair. Thank you.
Well, thank you, Chair. Good afternoon. And thank you, Ms. Abrams and your team. Just a few areas.
Mendo, you've also been sabotaged. Yeah, please
You
speak.
can't hear.
No, it was quiet. Yeah, we couldn't hear a thing. You just said just a few areas and then it went quiet.
Me now, Chair.
Yeah, please go ahead. I think we can hear you now.
Okay, and I just changed the source of network. No, thank you, Chair. Where we are explaining the functions of the panel of attorneys, of all the work they were dealing with in the RAF, you made an example with internal matters that they were also dealing with. For instance, the Auditor General matters, as well as the labor matters. I think we must find a way of splitting that so that it gives us a clear guidance in terms of the cost that is utilized in those areas. Because we don't want to conflate the issues of how much was the escalation in cost by not having a panel of attorneys and attribute it to one area of focus. Let's try and split that differently so that it gives us a clear picture. And the amount you have put in paragraph, I think it's paragraph 31. I know some of the areas in which we canvassed and you have spoken about, but you have split them in other paragraphs, were the issue of court roll monitoring, which is their tracker that was not there. And in the beginning of the document, there is also a clear explanation on one of the serious areas that is causing a problem of this escalation of cost in terms of appearances in court and preparations thereof, that lawyers are still sitting with the files and they are refusing to hand over those files. So I'm indicating these chairs because as much as there is this belief that there was no plan when the panel of attorneys was cancelled, but even after the panel of attorneys were not renewed, a plan that was put in action, which is the Office of the Attorney General, the state attorney, when there was a memorandum with the state attorney that RAF will recruit as many lawyers as possible. I think the start was 62 lawyers, if not 63 lawyers that were employed and worked with the state attorney solely focusing on RAF matters, was an ongoing kind of a project. But that project on its own had its own challenges because the preparations of court appearances mostly dependent on the files that 82 firms of those 100 firms have been refusing to hand over the files. We highlighted this in the beginning, Ms. Abrams, of the report, but on recommendations, we are quiet. We're not saying anything. And this has been the main contributing factor on the failures of the mechanism that was put in place in order to remedy the situation and ensure that all the work that was performed by the panel of attorneys has someone to perform. But even those people that were put in place cannot perform this particular work and successfully deal with the matters at court because they don't have information. Information is sitting with the other attorneys. Secondly, then there's a shortfall in terms of the court monitoring. That's the internal system which must be corrected as well. You have highlighted it, but on the observations and recommendations, we are not having a clear paragraph on what should be the systems, or rather, we, as much as we will not prescribe, but there's a lack of systems, internal system in terms of monitoring the court roll, or rather a tracker in terms of monitoring the court roll. And that monitoring of the court roll also relied heavily on those files that were there, even if there's a court date, but in terms of preparations, they show there's a short fall in terms of getting information, which is still sitting with the other lawyers who are refusing to hand over the information. And we also do not have a clear explanation as to that project of employing more lawyers, because 62 was just in the beginning. It was not Alpha and Omega. It was the beginning of the project. But then after that, something happened, and that is lost in our report as to what became a stumbling block in employing more people to the office of the state attorney. Now, there's another issue, Chair, that I feel we are conflating it, which is going to not help us a lot, is the issue of the medical experts that I forgot the name of the lady who came to give us evidence on this. I don't think we must vent this one of the medical experts on this report where they are not paid. I think it will be much more suitable or appropriate to deal with it under the Sunshine report. Why I'm saying this is because if we use only this one area of this lady, and she mainly said she's covering about 3 or 4 provinces. There's other provinces, there's 9 provinces in South Africa. But even with that 3 or 4 provinces that she was covering, she mentioned that there's many of them, even though they didn't come before us. But we cannot then be ignorant to the fact that the area of medical experts and the way in which RAF is dealing with, similarly to the one of the Sunshine Hospital, because Sunshine came before us, but which other hospitals are dealing with this and are paid huge sums of money versus to the state hospitals or state doctors that are providing the similar service of the RAF issues of medical experts and assisting the quantums and offers thereof. Why is it important that we must put it in the Sunshine? It's because in our observation, it should be clear that the system of medical experts privatized that are identifying people, similarly to what we asked Sunshine, how do they also get these clients of RAF? Because there is no Makulu of Ngutu or Kwakwa or anywhere that have become their client. Maybe there's 1% or 2% of that. But most importantly is that we have a system in South Africa of corruption wherein doctors or heads of hospitals are referring clients to these private hospitals so that they can get money, and there is a kickback in that process. And what is our job is to make sure that where there is this kind of practice in play, we ought to find a way of curbing it, and we ought to find a way of putting a stop. And there's privatization of the work which could be provided by the state, but then it's provided by private companies simply because they need to get into the fiscus of the state. And we then cannot enable such a situation where we are not speaking to that kind of practice. Okay, then the last one, Chair, on this one is the first paragraph on the observation where we say we cannot prescribe on what RAF should do. I don't agree. We all agree that one, the state does not have money. Two, the private sector is very expensive. In the beginning of this report, there is an argument which the CEO made that in terms of the cost overall that they have to pay as RAF to the private companies. He made an example with the photocopy that when they are issuing their costs to photocopy one page is R4, which I'm sure by now is R5 or R6, which makes no sense at all. That was but one of the areas, or rather examples, that were made to justify why it is not sustainable for the state to utilize this form of lawyers in terms of addressing the issues at RAF. So I do not agree that we cannot be prescribing to the board what they should do. They should follow what the minister had told them, that in order for RAF to save cost, they must insource all the services at legal. But the problem here is that that insourcing was sabotaged. The progress of the insourcing of the lawyers, or rather employment of the lawyers to the state attorney general, we are not told what happened to that. Number two, there are files that are sitting with the panel of attorneys, and we are not told what is the action in order for the RAF to get those files in order for those cases to continue. And number three, the systems of the court roll are a problem at RAF, even with the new cases besides the ones that are left with the panel of attorneys. The new cases, the lawyers, or rather the legal component at RAF, has no clue of which case goes to court at what day. So those are the areas that must be addressed. But we cannot then say, no, go and decide. You still outsource or insource. We are members of parliament. We can't then sit here and be neutral about what system should work at RAF in order to save cost. In order to save cost, they must insource. That will also address the high unemployment in our country, as well as dealing with the matters of cost and reducing cost massively. Because we cannot say the cost was reduced, but also the court judgments increased. Those court judgments increase simply because of the reasons I've already mentioned earlier on. Therefore, they can't be conflated to the cost. The cost was saved, but then another problem came up, and that problem is not as a result of not reducing cost, it's a problem as a result of the systems within RAF. Thank you, Chair.
Thank you very much, Honorable Mendek. Let me take Honorable Atkinson, and then we'll just have a short discussion and then continue. Honorable Atkinson, you can complete your earlier point.
Thank you very much, Chair. Yeah, I'm sorry for that break in conversation. I'm not quite sure what caused that, but anyway. But Chair, what I wanted to say was that what I do find quite shocking is the fact that, as Ms. Ibrahim pointed out in her report, that this situation continues to persist about the lack of legal representation on behalf of RAF, and the fact that there continue to be large amounts of money wasted and lost in terms of default judgments that are brought against RAF because they're unable to have the kind of level of, or the amount of legal practitioners that they need to actually correctly defend all these actions. So I do think it is something that needs to be taken up with the minister, and certainly in the report, I think we need to suggest very, very urgent action taken in this instance, because I think, in my mind, all boards that are appointed have a fiduciary duty to the state, that they're acting on behalf of the people of South Africa, and part of that is not to allow fruitless and wasteful expenditure And what is in essence here just I think just pure delinquency and actually not getting the situation sorted out. So I think this is a very serious issue that does need to be sorted and does need to be in our recommendations, that it needs to be done with the utmost speed. As I said when I tried to speak earlier, we became aware of this about 7 or 8 months ago. It has been persisting for a long time. Then the second point I wanted to make was, as Ms. Ibrahim pointed out, the actions of Mr. Letswalo and potentially some of the people around him, and going ahead and getting rid of the panel of attorneys without a proper cost-benefit analysis or without a proper plan in place was reckless, and again goes completely against any fiduciary responsibility you might have had towards the state. So what I would like us to look at is the potential of seeing what sort of sanction we can call for. But the fact that he so spectacularly failed in his duty to protect RAF, and just appeared to take decisions off the top of his head without actually too much consideration as to what the results of those actions would be. And to be honest with you, Chair, I don't think it would have been particularly difficult for him to have actually found that out. I mean, he's got some very smart actuaries there. He's got some very smart people in the Road Accident Fund that he could have consulted and asked them to do the calculations and to work out the effects of his actions. Obviously, that was not done. Seemingly didn't take any serious advice from people within the organization, and those who tried to direct him away from his line of action either got suspended or fired. So the 2 points I want to make is that I think that we need to suggest very, very serious and very quick action to resolve this particular issue, which continues to cost RAF a lot of money. And we also need to look at the level of sanction that we should be instituting against Mr. Letswalo and anyone else around him who is responsible for these decisions and actions. Thank you.
All right, thank you very much, Honorable Atkinson. I'll come to you, Honorable Skosana and Honorable Madlala and Honorable Kubeka, but I just want to make a couple of points of clarity. So the corporate labor, the corporate panel versus the claims panel issues have been separated. We will deal with the corporate panel issues separately because they also speak to the use of attorneys for labor matters, etc. That line of testimony, that will be the so. Anything you see here is a result of the claims panel specifically. So that is the first thing. The second thing is that the issue of the lawyers refusing to hand over the files. I think what maybe we need, I know it's written in the report, what we need to make it clear that even if you accept that those files were withheld, the default judgments are not arising solely out of the withheld files. They continue to pile up default judgments to the extent of 15 billion, even though the volume of claims in total that they process has fallen from over 250,000 to just under 70,000. If you took that into account, the difference, the default judgments should actually be falling because they are processing fewer claims, far fewer claims than before. In fact, they've fallen by over 70%. So the point being made is that even if you take that into account, they should not therefore be continuing to have a default judgment. So maybe we need to write that properly. The recommendations are not on here yet. As you will see, there's observation, so there will be recommendations in terms of next steps. There also is in the report a number of how many have been employed so far. It is in the report. Maybe it may have just been missed, but it is in the report. And it's also in the report the number of attorneys that they must still have. Members will recall that in the conversation, I had to beg Advocate Phillips, who was very evasive, to say, I am trying to help you get more budget for your insourcing. If you don't tell us how many lawyers you still want, we cannot put a recommendation in our report because you refuse to tell us. And eventually he relented. So So when we talk to the recommendations, I think we should do that. I also then, in this vein, I think the wording needs to be changed in terms of what we are saying. So the committee has said there was no cost benefit analysis. Objectively, really, there wasn't. Because if there was a cost benefit analysis, we would know how much the panel would cost per year versus insourcing, and how long it would take to realize a full benefit. I asked for that information from the Road Accident Fund more than once. They performed an exhaustive search. That document does not exist. They have simply never done it. I also asked on about 3 occasions for a project plan that identified how many cases they had, how many were in which stage of litigation, etc., and how long it would take to then introduce new state attorneys. They get familiar with the files, and then they're able to take them. They performed an exhaustive search. They looked at minutes of meetings. That document does not exist. So this is not a conclusion that the team has reached glibly. We did ask the Road Accident Fund for specific information for them to search for it, and they did not find it, even reference in minutes. To give the members comfort, for example, we got to know that there was a board decision about the direct claims, because there was a report submitted by the CEO, and in it was a table where there was indirect reference to a previous board decision to do away with marketing direct claims. From that document, then, we were then able to go back to the Road Accident Fund and ask for minutes of previous meetings to see where there might have been reference, at least to know who to call. So that's some of the process we're engaging in the background. And that's how we then knew that there was a formal decision, it was in a board submission, etc., etc. So I just want to assure members that when there is and maybe we need to place in the report that we asked for this information, the Road Accident Fund simply does not have it, because it was never put together. And then there is the issue of the medical practitioners that will be dealt with separately. It's one of the sections that is under quality control. What is important here for this purpose is that part of the reason it became difficult to process the matters in court is because the medical experts were being managed, in a sense, in inverted commas, by a lawyer from a corporate panel. That medical expert is being paid by the Road Accident Fund because they've got a panel of medical experts. So what happened is that when the law firm fell away, the legal practitioner that medical expert had been dealing with was no longer there, or could no longer work with them, which meant that, you will recall, Ms. Mtetwa says they ended up with files and files in the Johannesburg office that had no people, lawyers, attending to them. And therefore, the medical experts then would sit with a report which is going to expire in 2 years and not know who to give it to. And in turn, inside the Road Accident Fund, there was nobody to take that report and then prepare a court case and go. So maybe we need to also make that clear. But there is a section on medical reports. And then there is a sunshine matter. It's dealt with separately. We make reference, and I want to refer members to our discussion with the current board. The difficulty that the Road Accident Fund has had, and that we had, is that there's only one report dealing with sunshine. It's a forensic report that was performed by the Road Accident Fund. It found no wrongdoing. It scrutinized invoices to check whether they had been overcharging, and it found that they hadn't. It also took a sample of referrals and found that the state hospitals had referred the patients to Sunshine Hospital. it also said that it has performed a sort of a forensic look at RAF employees to see if there had been any collusion between themselves and Sunshine Hospital. It could not find any. I then, members will recall, when the new board was here, I said to them, the only report we can rely on is this one, which exonerates them. Please go and find if there ever was another report. They came back and said, there is no other report, it's only that one. We then further looked at the recent court cases. There were two. One was in February, one was last week, in which the only report that is available is the one that exonerates them. And in both of those cases, the Road Accident Fund has been instructed to pay Sunshine Hospital. So on our side, we've really have done an exhaustive search of any information that would point to wrongdoing on the side of Sunshine Hospital. We have not found it, and the Road Accident Fund itself has not been able to produce it in its own court proceedings. But we will then have to deal with it in that. And then the last point I wanted to make is that maybe we must just make clear, Ms. Ibrahim, that we are not saying what decision they should have taken in the beginning. We agree that they needed to cut legal costs. I think having over 20% of your claims being legal costs is an exorbitant amount of money. I think we should make that clear. I think what we are saying is that the manner in which the costs were then going to be cut was not done properly. It was not done properly. There was no cost benefit analysis, and to this day, the Road Accident Fund still cannot tell you which costs how much. I guess the point we should make is that we are not arguing for the retention of the panel of attorneys, and therefore we're not reviewing whether they should have been kept or not. We're merely looking at the governance. I think we can fix the wording in that regard. In the recommendation section, we should then make recommendations in terms of what should happen. My proposal would be the Road Accident Fund must perform a proper cost-benefit analysis and present it to the portfolio committee as well as to SCOPA so that we can see it, because we always want them to take the most economical and beneficial option in terms of developmental outcomes. Honorable Atkinson, your input is that the decision on the panel of attorneys, you want us to specifically say that it was reckless. Am I understanding you correctly?
Yeah, I think Ms. Ibrahim, in her in actually going through the presentation, there was use of the word reckless. I think
that's that. But you were saying there should be a sanction. I think let's have that discussion when we discuss recommendations. Honorable Atkinson,
sure.
we'll get a chance to do that. Yeah, we get a chance to. Okay.
Yeah. Okay.
Thank you. I just want to be sure that I'm not skipping any member. Honorable, I think there was Honorable Dis Kosana and then Honorable Madlala after, and then Honorable Kubeka. Am I correct? Honorable Dis Kosana, are you still?
I'm still here, Chair. I guess I'm going to ask the Chair. I know that perhaps it must not be interpreted, Chair, but Chair, I think we are taking too much time, Chair, on your own. Hence, we are going to take long. So your explanation is welcome, but I guess we are taking too much time, Chair.
Okay. I will speak faster, Honorable Skosa.
Yeah, thank you, Chair. Chair, my contribution, and I think, hence, we should not be seen as that we want to run ref, we want to get on operational issues. Even when we do that report, recommendations, we must be very careful, Chair, that we are not deemed as if we've got interest in running ref as a board, like the board, that we are in the oversight and we want them to account, but we should not be seen like we want now to be involved on their daily operations. And I think my only concern is that it's like I think we I'm not sure whether I'm going to put to this. I'm going to put it in a right perspective for everyone to understand that I'm not accusing anyone, but I'm saying we should not be seen, because perception is everything. That Scopa now wants to run the department. I mean, wants to run this road accident fine. We should be very careful. This issue of lawyers and Ibrahim, I understand a concern as well, but I'm saying, on the high side, we have to be very, 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 very careful that we don't get involved in petty issues as well. They must run and they must account to us. Where we found them, there must be a consequence management, right? Not be seen as that we are now executives or we are now a board of that entity. That would be my only contribution to it. Thank you.
Thank you very much, Honorable Skosana. Much appreciated. Honorable Mandlala.
Thank you, Chair. I wanted to just make, I think, one or two comments. Well, the first one is in relation to the decision that was taken not to renew or continue with the panel on the attorneys. And I think I want to just emphasize the spirit of our engagement when we dealt with some of these matters in committee, that we said we must look at structural and systematic and governance issues, so that we are able to generalize our report across SOEs and across any other similar entity, in terms of how governance should be run. So for me, in the issue of the decision around the state attorneys, there are two issues there. One is the issue of the delegations of authority, which I think is very important because it will then deal with who takes what decisions at what level. And then coupled with that is then the issue of the fiduciary responsibility of board members. So even if there is no board resolution on the decision, then the question is whether the CEO had the delegated authority to take that decision. If the CEO did not have the delegated authority to take that decision, then what repercussions should be there for the infringement of the delegations of authority? So that across board members can learn from this as a case study that if you allow, even if you don't take a decision, but if you allow for a decision to be taken outside of the framework of the delegations of authority, these are the possible repercussions, which may, among other things, include you, um, rendered. There's a word they use for a delinquent board member. So prohibiting you from ever participating in SOE boards and all of that. So that everyone then makes sure that they do accordingly, and follow the delegations of authority framework. So I think that's just the reflection that I think we should at least make in terms of this particular matter. But an excuse that a decision does not exempt the board from accountability, an excuse that there was no board decision cannot exempt all board members of the time from accountability if the delegations of authority did not allow for the CEO to take the decision. That's number one. Number two, I think it is important that we share. Well, I share the sentiments of I think it was Honorable Mente, if I'm not mistaken, but the sentiments around the importance of insourcing the service. I think the decision was a correct decision. It's a process flow that I am uncomfortable with, because there's not been much given in terms of account. So, but the decision itself to insource the services must be welcomed within the context of moving towards ensuring that we promote direct claimants, because what is the effective use of lawyers if we're able to maximize the capacity of assisting claimants to ensure that they've got direct claims? So we may study feasibility or whatever form of study which may be conducted to look at the jobs that are there, the quantity of the claimants and all of that, may actually arrive at a conclusion that if we maximize promotion of direct claims, we may actually have to minimize on the appointment of attorneys. We may not need as many as we would if many people claimed through them. So those are some of the reflections and the comments that I wanted to make, Chair. Thank you.
Honorable Magala, thank you very much. Those are appreciated. The team, by the way, also in our report, we've got an obligation to reflect everybody's views in the report itself. So those will be reflected in the next version. Honorable Kubeka.
Thank you, Chair. And greetings to the House. I'm not sure if I'm audible.
I didn't say Kubeka like that other fellow who came the other day.
No, at least, Chair, you are familiar with the surname, Chair. So we forgive those that are not familiar with the surname. Chair, I think on some of the issues that we are raising here, I think at the end of the day, the idea behind us embarking on this journey into looking at draft was to help them fix the issues that they have at the road accident fund. Now, Chair, once we have finished, at the end of the report, once we've noted what has happened, who did what, when, and how, I think we equally have the obligation, or we're obligated to look forward and say, okay, this is what has happened. We came in, this is what we fixed, and this is the end result once we have fixed. Now, I'm worried, Chair, that during this process, I'm not too sure if we're actually winning in that department in correcting whatever issues that need to be corrected at draft. Now, for instance, when we spoke, when we last had the interim board at draft, there were some issues that were raised there, actually. And some of those issues included there being no one who was going to give, or there's no one who's giving RAF lawyers a mandate. So, Chair, I'm not sure if we need to have that in the report that we're currently drafting, or if it's something that we need to look at on the side, or if it's something that we need to look at once we're done with this report and say, okay, we're going back to RAF. How do we help them fix whatever? But that's just on a comment side, Chair. Now, Chair, earlier on Honorable Mente spoke about the lawyers that were on the panel of attorneys who refused to give back briefs, or who refused to give back documentation related to cases that they were working on. Chair, I would like to echo Honorable Mendes' sentiments in that is very significant, Chair, because I think from where we sit, we're not sure regarding how much or how many of those cases are actually affected when we speak about something like that. So I think that is worth noting. And then, Chair, when we issue the report, I think we must put it on record that, for instance, the issue of I know Sunshine Hospital is in the news currently about them being settled and all of that, but can we also put it on record that they are not a road accident fund hospital, as they purport themselves to be, or some people purported them to be a road accident fund hospital. They are not a RAF hospital, and could we put that in bold that Sunshine Hospital is not a RAF hospital? We understand that them collapsing was because they were shut out of RAF in one way or another. But if they were a normal hospital, they shouldn't have closed down. They only closed down, and this too we need to note, they only closed down because they stopped getting clients from RAF. Now, Chair, I don't want us to hide the fact that as much as they may have helped certain people who had injuries at Sunshine Hospital, some of what they were doing was not entirely above board. So can we also note that, please? And then, Chair, I know earlier on we spoke about the rough one form. Can we also emphasize again? I think I've said this before. I'm not sure if the team that is scribing for us wrote this down, that it was only available in English. As complex as it was only available in English. Can we note that? And then, Chair, I'm not sure where in this report this one will go regarding Project Bokamoto. Project Bokamoto came at a staggering cost of around 850 million rands, almost R1 billion, to automate claims processing, and yet it's still not functioning. That, Chair, is an indictment on its own, and I think someone needs to answer for that. And I think maybe if we could also note the issue there that, you know what, we've got a project here that is being paid almost R1 billion that is not functioning properly. Okay, we put that on the report. And then, Chair, outside of Mr. Letwalo's actions in as far as dismantling the panel of attorneys, if that was his own decision, that is, can we also note what was the role of the board in the dismantling of the panel of attorneys? Because I don't think that it's accurate to absolve the board of the consequences of that action. And then I think other issues that we could note, and again, to the scribers, I apologize for this because I'm not too sure where in your report we can add this. The many issues that have been there, and I bring it up now because the problem is they continue to exist. The paper-based system that is at RAP. I think when we spoke to the chair when we last came to see us in Scotland, he echoed the same sentiments about the problematic paper-based system. It has not been fixed. They are polling record keeping that has not been fixed. And then the 385 positions in the legal department that are vacant, that too has not been fixed. Now, I'm not sure how do we highlight that, Chair, but I think our scribers will help us to ventilate those issues adequately. Thank you, Chair.
Thank you very much, Honorable Bubek. Just a couple of comments before Honorable Skosana beats me up. So Sunshine, all matters relating to Sunshine will be properly ventilated in that portion that is relating to Sun, that is undergoing quality control. The rough one form will also be dealt with alongside Bokamoso, because if you recall, the way Bokamoso was being designed was in line with the rough one form, and there are some risks and issues there. So just to say the members that there will be an opportunity to deal with those things properly. And also just to say to Honorable Madlala, noted as well, and Honorable Kubeka, there's a couple of things that you mentioned here that we need to take into account and be specific about them in the report. That will also be taken into account in the next version. I think with the benefit of all the inputs on the various sections, we will then formulate a draft recommendations for the committee right across the board, because some of them are interlinked across the different areas, including whether the board was exercising its fiduciary responsibilities properly. And we'll also set out there that the management, the chief executive and CFO are not part of the board at the Road Accident Fund. The accountable authority is the board, which includes all the non-executives. So we have to take all of those things into account in terms of what we think by way of consequences and so on. So I just want to assure members that we're taking all of those comments on board, and then we will then reflect those in the next version, which will be a complete version of the report with the highlights in yellow in terms of where additions and edits and comments of members and so on, so that everybody can locate the comments they made with greater ease. Honorable members, I don't know if there are any more hands. It's 1:05. Yeah, Honorable Kubeka, that's an old hand. So yeah. So honorable members, if there are no more comments, I would like us to adjourn here. Suffice to say that we, in terms of the other processes like getting a Transnet back, that letter was prepared on the same day, setting out what they need to come back and report on. The PRASA process is also underway in the background, so that we can also make a determination about what they should come back and talk to us about and when. Ndando Ms. Cenge is preparing the oversight reports on BCM and OR Tambo. So there is work that's happening in the background, honorable members, alongside this process of the road accident fund, so that we don't fall behind in our work. Otherwise, honorable members, thank you very much. I would like to wish everyone a good rest of the week, and also safe travels for those who are traveling during the Easter break, and also some good time with constituency work, as well as a bit of leave over the next little while. So thank you very much, honorable members. We can adjourn.
Thank you, Chair.
Thank you, Chair.
Thank you, Chairperson. Thank you.
Thank you.